All right, so the first case on the calendar, this is the March 19th, 2025, 10 a.m. calendar for, this is the civil motions calendar. And first case on the calendar is Sally Anderson versus John Doe and Just Me and Rupert Law and Ashwood Ridge Holdings.
We're ready for plaintiff, Your Honor.
All right.
Your Honor, Frank Bettinger for Ashwood Ridge. We are the only movant and the only defendant represented by counsel.
Okay. All right. Is there anyone here on behalf of Just Me and Rupert Law?
I don't believe they've ever made an appearance.
Okay. All right. Just wanted to make sure. All right. So this is for a tort premises liability case. And I'll go ahead and hear from the movant.
Yes, Your Honor. Again, Frank Bettinger for Ashwood Ridge. This is a very simple case. The plaintiff alleges that she slipped and fell and sustained injury in the common area of the apartment complex. She alleges that this was a hazardous area and the landlord should have done something to prevent her. The problem with her case and her claim is she used this exact same route to come to and from her apartment and the parking lot, which was her destination this day, for 8 years, weekly. And therefore, she, the plaintiff, had at least equal knowledge of any hazard, and we submit there was no hazard. But if there was, she used it all the time, repeatedly, for 8 years. She probably still uses it. I don't know that, but old habits die hard. And therefore, we think this is a simple case of equal knowledge, if not superior knowledge, of any hazard, and I'm not conceding there was a hazard, that the plaintiff felt.
Hazard ever reported?
Say again?
Was there a hazard ever reported?
She contends that she complained to the office before this happened, not so much about the hazard, but rather she was afraid that the pine trees might fall on her unit. She had an end unit apartment. But she doesn't know what she fell on. And I suggest that's because she simply wasn't watching where she was going.
Okay, and the lobby was interior, entirely interior?
Say again?
This was an interior lobby, not like a breezeway?
No, not at all. This is an area of open land, grass, if you will, trees, if you will, that was the border of the apartment complex. It was an area between her apartment building and the paved parking lot. It was natural. And it's the same way now, I do believe. And it was the same way from the first day she moved in 8 years before this incident. So she is traversing an area of the property with which she was intimately familiar. She used it all the time. It was her chosen path.
Were there designated walkways, like, you know, how people might take a shortcut over the grass, but were there cement pathways?
There were, and she admitted that if she had gone straight out of her apartment to the asphalt pavement, she could have traveled along that pavement directly to her destination and never encountered any pine straw or pine cones or loose limbs, whatever it was that she claims caused her to fall. She says she slipped in her deposition and her one leg went one way and her one leg went backwards and she twisted her knee. But the important point here is that she was intimately familiar with this path. And if there was any danger, she assumed the risk week after week, month after month, year after year. And we don't think the law will allow her to suddenly recover from, if it was a hazard, and again, I'm not conceding that, a hazard of which she knew better than maybe anyone at the complex because it was right next to her unit.
Mr. Hendricks, slip and fall law is pretty concrete when it comes to the tenets of, equal knowledge and having access that would give you knowledge over and above what the landlord would have. In addition, in this case, there was a designated path for travel, but your client deviated from that path. What makes this a case where the court would find that there's a genuine issue of material fact?
Morning, Your Honor. It's Louis Hendricks for the plaintiff for the record. Your Honor, we don't agree with the way this is being presented at all. There's one picture attached to our brief, which is a joint exhibit, a picture produced by the defendant. It shows the front of the apartment. It's one of those places where it's a row of like 5 apartments, single story. Each of them will have a door at the back and a door at the front. She was not in an end unit, not that it's even relevant. But anyway, from that picture, you will see there's a corridor going down towards where she walked. That's at the front of every apartment, a continual place. And there's steps at the end of it. That's where she went. That was a place designated to walk. Corridor and the steps going down. And Your Honor, the fact that she may have gone there before. This is not a case of a static defect. Not that kind of case at all. The way Mr. Bettinger is suggesting is that if you go to the grocery store and go buy the milk part all the time, and you have done it for 15 years, the fact that there's water now on the ground that you didn't see and the management knew about, he's going to say, well, you have been walking here every week for 15 years. He doesn't mention incidental hazard that was there that you didn't know about, that they knew about. In this case, what we have is unrebutted testimony from my client, the plaintiff, that when she told the manager that she had fallen, again, note, Your Honor, it's after she fell, she went and made a complaint. The manager told her that 2 other people had slipped and fell on the lawn also. So they knew about the sort of poor maintenance that led to all manner of hazards, like some round things acting like roller balls under her feet. And that's what she realized after she fell. Your Honor, we cited a case where at a gas station, a customer, the case is Flood, on page 5 of our brief, gas station, oil and gas, customers buying diesel fuel, and slipped and fell on oil. The Court of Appeal said, well, okay, she could have seen the oily nature of the gas station pavement and all that. But the problem with that was that the management knew that one of the pumps was leaking oil excessively. And that created a kind of different situation. And they found that that was not fit for summary judgment.
Was this,
sorry, Your Honor.
I'm sorry, I interrupt when a question hits me because I'll forget otherwise. Was this a situation that was occasioned by a sub lawn care, somebody doing work on the property, or was this generally, from the perspective of the plaintiff, a hazard that was caused because the landlord failed to maintain the premises?
Yes, on both counts, Your Honor. The Rupert defendant is in fact was the lawn care company. We think, we still can't verify, But because we could never verify through discovery exactly who was responsible to take care of the lawn, we cited cases in our brief that ultimately the landlord is responsible. That, we cited toward the end, the last part of the brief is talking about that the landlord can't be excused because an agent was responsible to take care of the lawn. So we're still saying this was during COVID, and probably they have excuses, so to speak. But Judge, the situation with the lawn had changed, and this was an area where the tenants were expected to walk. It is true that she could have come out the front. In that strip you'll see in the picture, cars are backed up right to the apartment front, and there's this big 4 or 5 feet wall corridor open, and that's where people would come out, step down, go into their cars, or they would walk down and go down those steps. That's where she was going. Now,
Okay, and one more question.
Yes,
So
Your Honor.
you said, have we identified the actual, were those like just suggestions, or have we actually identified the alleged hazard or whatever she slipped on?
Some buds, as she describes them, some of those trees that let go of some round, hard things. I don't know the name of the tree or anything, but she saw all this after, when she was there after she got up. Now she saw exactly what happened to her, but she was just walking normal. Now her point is that had they been doing the lawn care, she had lived there for years, but they had slacked off. Whether they decided to become slum landlords because she's a poor lady, disabled and all that, that's the kind of complex we have. They simply let it go, and she was just there. She didn't go outside every day like that. She didn't necessarily go. The testimony, the evidence, you will not find evidence that she walked in that direction, across that place every week in the testimony, because I don't see it. I don't recall it. But she knew it. She has gone there before. But again, Your Honor, it's not static. There's no excuse for the landlord not to clean up. They slacked off, and they knew, according to my client's testimony under oath, questioned by Mr. Bettinger, that the manager told her 2 other people had fallen before her. That's what she says. Now, that's not rebutted.
Hold on.
Your Honor, I hate to argue.
You can clean it up in a minute, Mr. Bettinger.
All right.
Hold on. Last question, Mr. Hendricks. So
Yes,
I have pecan trees near my driveway. And there are times when the pecan tree is shedding, and we'll have these little hard pecan. They're not very good. I don't know what brand this is because that's not the kind I like. But anyway, they'll be shedding onto my driveway. And if I walk out, if I'm not careful, could slip because of the debris from the tree. And it's a constant. Like even when my kids use the lawn blower and clear it up, 10 minutes later or an hour later or a day later, there's going to be more shedding. There's going to be more pecans on the ground. In this case, you're stating that if this is the type of situation, because you're saying hard tree buds, so that could have been walnuts, pecans, any of those things. It could have been actual buds, plant buds. That the landlord has a duty to maintain that constant, even though just naturally it's going to happen. Like leaves, you blow all the leaves are going to come back.
The answer would be, Your Honor, the landlord was responsible to reasonably prepare the place. We are saying that what they did and failed to do, rather, was unreasonable. They slacked off on the maintenance and simply dropped the ball on that. And poor Miss Sally going out there, not aware of that and not aware how hazardous it would be. And not only that, Judge, taking her testimony, because she's the only one who testified about this, that she told the manager, Mr. Goins, no, I'm sorry, he told her, 2 other people. Now, they had every chance to rebut that. They never did. He never filed an affidavit denying that. What he says is she walked somewhere completely different. So what we have is a dispute in the facts here, Judge, because he's claiming she walked one way and she's saying she walked another way. So the evidence itself, despite brilliant argument from counsel, the actual affidavits, the depositions, you'll see big time conflict in what happened. And with your pecans thing, Your Honor, Does it get to a point where it becomes unreasonable for the person in charge to clean who doesn't clean? Can it ever get to that point? Like the gas station case in flood? Gas station will have leaks, yes, but can it ever be unreasonable? The Court of Appeal says yes. If you have a pump that's leaking inordinately amount of oil, diesel fuel on the floor, people are walking, they wouldn't expect that, and they slip, you can be liable. So this is similar, we believe, Your Honor.
Okay. All right, Mr. Bettinger, you had some rebuttal for the argument.
Yes, Your Honor. This is not a leaking oil pump analogy. This was a natural setting, just as God intended it to be. Trees drop pine straw, drop limbs, drop buds, drop whatever. And there were alternative paths that any tenant, including Miss Anderson, could have taken to get from point A to point B, her destination, without ever setting foot on that. She elected to take a shortcut repeatedly. She doesn't know what she fell on until after she fell. And this is proof that she wasn't looking where she was going. She wasn't looking at the ground to see, oh, I wonder if I should step here or not. She was going to meet her husband and her son in the parking lot. That's unrebutted. And the manager was never deposed by Mr. Barrington. We set up 2 depositions. I took the plaintiff. Mr. Goins was present in the room with me when we deposed Miss Anderson, and plaintiff's counsel declined the opportunity previously arranged to depose Mr. Goins. So I take strong exception to, after the fact, the plaintiff submits an affidavit saying this. I could have perhaps deposed Mr. Goins. I could have re-deposed the plaintiff. This was out of the blue. And Mr. Goins, by his affidavit, testified he never talked to her in the office simply because COVID had just come down. We ask in the brief, this incident happened mid-May 2020. That's 2 months after the lockdown went into effect. And he's testified that, number one, nobody came into the office. The protocol was you knock on the door, someone from the office will come, open the door, stand a safe distance, take down your message or complaint, and then have someone get back in touch with telephone. Mr. Goins, in fact, was not even on the property. He was managing it from a different complex. The only interaction that he has testified to by affidavit is after this woman complained, he arranged to meet her out in front of her apartment, again, safe distance. To find out what happened, she told him an entirely different story of an entirely different path of travel, not to the parking lot, but to the dumpster, because she was taking her trash out. And again, she took a shortcut over a wooded knoll. Now, it doesn't matter to plaintiff's case which version is the truth, because either version has her assuming the risk of whatever problems she encountered by taking a shortcut. That was her choice. And defendant should not be responsible for that. Your Picantry example in your own home is on point. I don't know what she tripped on, but what I do know is that she did not testify to anything in particular in her deposition. Mr. Barrington says she was walking normally. Well, she can't have it both ways. She can't elect to use this, walk normally, and not pay attention to where she's going or what she's stepping on, and then turn around and say, oh, it's someone else's fault. And again, this is not a gas station analogy where this happens one time. This is not a grocery store analogy where a woman trips on a grape and the grocery store says, oh, we checked every 15 minutes, it wasn't there. This is something that she knew of and freely chose as her path for 8 years. You cannot hide behind that level of familiarity and claim, oh, it's not my fault. And there is no evidence in the record that there was any slack off in maintenance because of COVID. That is argument from Mr. Barrington. I don't begrudge him making argument. I'm making argument that she didn't see what she slipped on because she wasn't looking where she was going. But there is no evidence in the record from anyone. The landscape entity sued by the plaintiff was never served that I'm aware of. And they certainly never appeared, and no one took testimony from them. So I think it is speculation that they had slacked off. One of the areas of our economy that was able to keep going during COVID were the people who worked 20 feet away from everyone else. I would argue that the landscaping carried on because that's the safest place to be, in the wide open, fresh air, by yourself, picking up limbs or leaves or whatever. But there is no evidence of any slack off here. This is plain and simple superior knowledge by the claimant, assumption of the risk, and under Georgia law, she must show that the landlord had at least equal knowledge, and she cannot. She had superior knowledge. We argue at a minimum, she had equal knowledge of any hazard because this was a path she used regularly, and not just for a few weeks, 8 years. We believe summary judgment is appropriate under these facts.
So for both of you, you're all well versed in the cases that involve the summary judgment. I mean, slip and fall cases and summary judgment with respect to slip and fall cases. And so, having heard your argument, I'll take another look at the written documents, the affidavits, and I've made copious notes regarding your arguments, and I will direct my order in the way that the court would allow and permit. So you'll get an order from us as quickly as we can, so you will know whether we're going to trial or whether this case has come to an end. Okay?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you all for your patience also.
No problem. You
at
helped
all.
me. I owe you one. Thank you, Judge.
All right, gentlemen. Thank you so much. You're free to go at this time. All right. The next case is LaTanya Denise Turner versus Brian K. Widener, State of Georgia, Salah Holdings, Define Gresham, and Larry W. Johnson. All right. Is there Ms. Turner, LaTanya Denise Turner?
Yes, I'm the attorney, in fact, on behalf of the principal, who is the resident agent. I have also already submitted forms appointing the judge over this matter to administrate on behalf of the principal. And I also submitted the rest of my entries on records. Now, with that being said, the Form 56 appointing judge.
Ms. Turner, I got to see you first.
Okay. I'm trying to, there I go.
Okay, there you are. All right,
Okay.
so Ms. Turner, very quickly. I've reviewed the information that you provided. First of all, you're suing with respect to a foreclosure, which is a situation that involves land and a determination of ownership with respect to land. That is not my jurisdiction. I'm in state court. State court does not have jurisdiction over determinations of land. We deal with dispossessories, which is a temporary situation with respect to land, the allowing someone to use your land in exchange for rent or your property in exchange for rent. But we do not deal with the whether a foreclosure is proper. So in this case, this court is going to have to transfer your case to the Superior Court of Clayton County, depending on whether this is Clayton County that's involved. And so I see you're suing the state of Georgia. Not sure how they're involved. Not sure how any of these parties are really have an interest in this case. But with respect to the jurisdiction with for foreclosures, that is not what I do. Okay. All right. Is there anyone else here on behalf of any of the other parties who either disagree with what I've said or who have anything that they would like to put on the record?
So, Your Honor, this is Larry Johnson. I
Yes.
represent Brian Widener as well as myself. I just want
Okay.
to point out to the court, this was initially filed and I was not named. And
Okay.
after I filed an answer on behalf of Mr. Widener, the plaintiff just stuck my name and added it to it without a court order. And at that
Okay.
point in time, she needed a court order. So I'm not personally, I mean, I'm only in this case because I filed an answer for
Yeah.
Mr. Widener.
Intended to name me too. So, Ms. Turner, I know you have a set of beliefs about how the law works, but the way we do it here is just because somebody files on behalf of another person, everybody's entitled to have an attorney represent them. And so you can't then sue the attorney for giving them a defense. So everybody who comes into the case doesn't get sued individually. Like there are people who are responsible allegedly for what you are contending happened, but then there are other people who they choose to hire to help them navigate the case. For the people who are navigating the case and for the judges who are dealing with the case, you don't get to sue them because they don't have an interest in at that level. They're just trying to help the other person navigate the case, okay?
Could I get finished recording my interest on record?
No, ma'am. You've done that. You're the plaintiff.
Okay. Well, Judge, I would like to record my interest on record.
I'm not sure what that means, ma'am.
I'm the attorney of fact on behalf of the principal, who is the registered agent. I already
Okay.
submitted the Form 56 upon you over the matter to
Okay,
administration
I
on
don't-
behalf of our principal.
Ms. Turner, nobody
Okay.
gets to appoint me over the case. I'm already appointed to whatever's assigned to me through the clerk's office.
I appointed you through my for my trustee. And Your Honor, I would like to add also to the case and ask you a question.
No, ma'am.
Yes or no?
The question that I'm not going to answer any questions because this is not my jurisdiction. I'm going to transfer the case to Superior Court and let them sort it out because land use and land and interest in land is under the jurisdiction of the Superior Court. Okay, so we'll get you an order. We'll also dismiss Mr. Larry Johnson from the case pending whatever the Superior Court decides because he's only here to represent the defendant, which the defendant has a right to hire an attorney to represent them, and that attorney doesn't deserve to be sued because they are helping somebody defend themselves.
This case
Okay,
is also
so-
in the federal court also.
Okay, then if it's in federal court, then it probably doesn't need to be here also. You shouldn't have a case running in two different courts at the same time. Okay, that's just going to cause confusion. And you're not going to achieve what it is you wish to achieve.
Okay, Your Honor, I know this court has no jurisdiction per 12 CFR 1500. And also, is there or should there be an investment in private residential property in the United States? Or
Ma'am,
is
Ma'am,
deposit?
that is a question bigger than any of us can handle. People can invest in whatever they spend their money on. So at this point, I think that you're going a little bit too far afield. Like I said, we're going to go ahead and transfer this case to Superior Court, and my brother or sister judges on Superior Court will help you sort out what it is going on. Okay. All righty. So we'll go ahead and get an answer out to all of you. Get an order out to all of you, transferring this case to Superior Court. But just as an aside, Miss Turner, everybody who comes in as a representative of somebody else, if they're an attorney, don't sue them because it just makes the case harder to get through. Okay, if you want to achieve something with respect to finding out what happened with your foreclosure, don't keep adding people to the
Your Honor, in this executive branch of law, I have a right to sue the attorney, anyone else
Okay,
involved.
Miss Turner,
In this executive branch, I do have a
Ms.
right
Turner,
to sue them and
everything
anyone
you
else
say
involved.
is nonsense. None of what you're saying makes sense. None of
It's
what,
fe-
Ms. Turner,
It's
trust me.
federal law.
Ms.
It's
Turner,
federal law.
Ms. Turner, we're not in federal court. None of what you're saying makes sense. You haven't established an estate. There's no trustee. You're giving us word salad. You're just saying stuff that you've read or somebody told you was appropriate. It's essentially called a sovereign citizen, but
No, it's not a
if
sovereign. It's not. I'm not a sovereign citizen.
those things
No,
work,
that
ma'am,
don't
everybody would
don't
use
put that on me. I'm not a sovereign
Ms.
citizen.
Turner, you've made statements that sovereigns use, and so I'm
I
telling
have my
you,
trust set up, and
okay,
I'm not a sovereign citizen.
yes, ma'am.
I am a person working in my trust,
Okay, if
not
you
a
say,
sovereign citizen.
all right, Ms.
That's
Turner.
against the law.
Okay,
I'm not a sovereign citizen. So I have my trust set up
okay,
in a way that it's working for me, and I have it set up.
okay,
And that's what I'm working on, my trust.
okay. All right, so we'll get that order out. Thank you. You're free to go at this time.
Thank you, Your Honor.
All right, next case is Koja Property Solutions versus Fantasia Mac.
Good morning, Judge.
Good morning. Are you Miss Mac?
Yes, I am.
All right, I'm gonna put your name on the screen, okay?
Okay, thank you.
All right, so who's here on behalf of Koja Property Solutions? Koja Property Solutions. All right, and Miss Mack, so you're here for a petition for review from your dispossessory, is that correct?
Yes, Judge.
Okay, one second. All right, so my understanding is that you received a writ of possession, but the money judgment was zero from the court below. Tell me what's going on, ma'am.
I was staying at this property owned by a man named Darren Stewart. I got the property from him in May of 2023.
Okay, and when you
Uh,
say staying at a property, were you renting a property?
I was renting, correct.
Okay, and what type of property?
Yes,
Apartment?
hello.
It's a house. It's a
Hello? Hold
four-bedroom
on,
house.
Hello?
Hi, good morning. My name is Lynn. We recently mailed you some details about new Medicare benefits.
Okay, whoever's with the Medicare, Kwaku? Hello? Okay, go ahead, ma'am. So you're renting an apartment?
Yes, I was renting a house. It's a four-bedroom house.
How much were you
And
paying per month?
1,500. I
Okay.
paid a 1,500 deposit also,
Okay.
which the court appointed for my judgment to be zero and for me to get my deposit back. They actually stole my deposit and did not give it back.
Okay, how long were you staying at the place?
About 10 months.
Okay.
There was no lease agreement.
Okay, so let's not say that. There's a lease agreement as long as you're in the property and you're paying them rent. It was no written lease agreement.
It
Is what you're
wasn't a written lease agreement.
okay,
Yes.
so you were to be able to occupy the property as long as you paid them $1,500 a month.
Yes, ma'am.
Okay, now tell me why you ended up in the dispossessory court.
I ended up in a disrespect. I ended up in the court because Darren Stewart started making sexual advances, asking me to come to California with him instead of paying the rent, and I denied it. So he began to get property management, which is Koja. He got her in October, but I didn't start paying her my rent until November 1st of 2023.
Okay, and you paid on time?
Yes. They were trying to basically say that I was late for October. I still paid my rent November, December. The problem was they were taking in October because of the situation between me and him. He wasn't supposed to be contacting me anymore when he got new property management. He continued to reach out to me, so I continued to let them know that I didn't want to live there anymore because I felt unsafe. So by that time, that's when Koja came in and said that me and him shouldn't have contact and I should be paying rent through her, which she set up a bank account. I put the funds in there. She lied and said that she didn't receive them, but I had the receipts and the account was set up by her. So then that's when I just didn't want to live there come January. I asked them what is it that we can do as far as like the rent payments and going forward, because I felt like there was cameras in my house that I didn't know about. There was just a lot of things going on. His
Okay.
son
All right, but
physically
hold on. So, you didn't have a written lease, so presumably, you could have told them, "Hey, I would like to leave."
yes,
Did you do that at any point?
yes, I did.
Okay, when was that?
That was October of 2023.
Okay. And so you're suing on a counterclaim. What's your counterclaim based on?
The rent that I paid because the nothing that was supposed to be fixed in the house was fixed. The toilets cost me over $800, which the water company did look into that. Um,
Okay, so
the
let's go back. So, the property of rental property law in Georgia is that as long as you occupy the premises, you have to pay the rent.
Mhm.
Anything that is you give notice about that's not repaired in a timely or reasonable manner, then you can use the payments that you made to repair it as an offset against the rent that's owed.
Which
But
I did.
okay, so you had receipts.
Yes, I have. I'm sorry, I don't know what it's called. It's called a when they send you basically like an estimate and everything of everything they did. They sent me
So
that
did you pay
basically.
the estimate?
Yes.
Okay.
Basically, he sent more people out, which I ended up finding out were just his friends, um, like just family, his son or his friends, or nobody that was actually professional to come fix these things. My blinds were supposed to be replaced. He never did it, which is one of the
Did
things
you
he said.
did you seek out individuals to do the work?
Yes, I seeked out for the plumbing. Yes.
Okay, so tell me about the plumbing.
So the plumbing was done in I want to say October too, in November. Which he said that we could work out something. I asked him what could we do, considering the fact I was coming out of pocket. He told me that we can work it out by basically me flying out there and giving him a sexual favor.
Okay,
Um,
so that's what's called a meretricious offer or a meretricious agreement. It means that it's not legal.
okay.
That so what we have to deal with is what the court can legally consider. So
Mhm.
you're paying $1,500 a month. How much did you spend in total for the plumbing?
I spent I want to say like 800, anywhere
Okay,
between like 830.
all right. So, and what month did you spend that in?
October.
Okay. All right. Did you spend any other money to have repairs done?
No, because every time I would, he would tell me not to, that he was going to send someone.
Okay. All right. And so what is it like, because that would have offset your rent for the 800. would have been an offset to the 1,500. And you said you didn't, that was all of that you paid out of pocket. What is it you're seeking for the counterclaim?
I'm seeking basically my rent that I paid back because the whole time I was not safe. Um, Basically sexually assaulted.
Okay.
Nothing was ever fixed.
All right, but you remained in the property.
Right. And also I found out that he was also rent gouging. So his family ended up telling me that the property of the house was only $500 a month. And I was paying triple of the property.
So, Miss Mack, here's another tenet of landlord tenant law. So a lease is just an agreement between the parties. So it is essentially whatever you agree to pay. So even if he has a property that would be market value $500, if you agree to pay $1,500 and you have not looked at what the market costs are for the type of property that you are in, then the market is whatever you agree to pay. So if you agree to pay $1,500 and you lit in exchange for you living there, that's what the lease is. So having other people tell you it's only $500 doesn't really mean anything because you agreed to pay $1,500.
I understand.
Okay.
Well,
So
the rent had never not been paid. They tried to say that the rent wasn't paid, but I was making partial payments and she was accepting them.
okay.
Around January 14th, I was assaulted by Darian's son, which I did not feel safe living at that property, like I said. And basically within 2-3 days, I had a letter in the mail for basically for me to be evicted. We went to court. I showed the court everything. I could have still stayed in the house, but I chose to move and I didn't owe anything. I just wanted my deposit back. Literally a couple months ago, I got a letter in the mail basically saying that they had took me back to court for whatever court fee she had paid to take me to court. Um, when I got to the court, that was my first time hearing about it, but they ended up letting me know that they had been filing since July of last year, which I didn't know because they were sending it to their address so that I wouldn't get the mail. So I didn't receive getting that mail until this year of 2025.
Okay, so let's talk about the deposit because I understand now why the court below issued a 0, because if you're still living in the property, even if you're paying partial rent and they're accepting that, you're getting kind of an offset for the rent, but you're still in the property. You're still entitled to have $1,500 unless you spend money to have repairs done that they did not do. Okay, so we're even there, but let's talk about your deposit. So there's a procedure by which a landlord has to give you notice and the opportunity to do a walkthrough and the opportunity to dispute any claims for a security deposit that they're going to keep. Did the management company give you notice that you had the opportunity to walk through when you left the premises?
No, I did my own walkthrough when I moved out. I took a recording and a video of the whole property, front and back.
Did they provide you with anything, even if you all didn't walk through together, did they provide you with a list of perceived damages to the property that they were going to keep your security deposit for?
Not until after 45 days. After all of this happened, I asked literally within that week, could we do a walkthrough? All she did was give me a code to a key. She never came to do a walkthrough. I also sent the videos to her, letting her know what the property looked like when I left out. 45 days later, when they were supposed to be returning me back because she said they had 30 business days in order to give me back my deposit. So after 45 days, she sent me an email of list of things that were wrong in the property that actually were already wrong before I moved in. The property looked better when I left than when I came in. I couldn't even move in for the first 2 weeks, even though I paid rent and a deposit, because the house was so filthy and it had roaches. So
And you
I
said
had,
it was 45 days?
yes.
Okay. All righty. And they never returned your deposit?
No, ma'am. And tried to charge me extra. My deposit was 15. They tried to charge me 17.50. and his family let me know that he never had anybody professional come in there, that his son just painted the floor. He told me that the floors were redone and renewed. That's why I couldn't move in, because technically I was supposed to move in June. May, June. No, I was supposed to move in April. So I couldn't move in because he said he was getting the floors done. But his son and family let me know that he never got the floors done. He just got a finish, like a polished paint over the floors. And he charged me for that. This person, Darren, he also, his previous owners before me took him to Clayton County in court for the property also. That's why he's not doing it in his name. He got a management team.
All right. So, Ms. Mack, all right. So what you've provided the court is, because the management company has failed to appear, you've provided undisputed claims of the management's failure to adhere to OCGA 44-7-35 with respect to security deposits. So that the code section is 44-7-30 et sec. So all of those things that have to do with the security deposit. If your security deposit was $1,500, they did not give you the account for an escrow account that your deposit was deposited in. They did not do a walkthrough within 30 days of you leaving. They did not provide you a list of the damages for which they claimed that they were keeping the money. Then you're entitled to 3 times the security deposit. So you're entitled to have $4,500.
Okay.
The court is going to grant you a judgment in the amount of $4,500 against the landlord in this case.
Thank you.
All
So
right. So we'll present that order and we'll send it to both parties. But just a couple of things, ma'am, please remember that a lease is just a contract. So whatever the terms are in the lease, you can negotiate on your own behalf, and you're also not bound by just what they tell you. If you do your research and the market is different, then if they're not willing to negotiate, you may want to go elsewhere. But as long as you're in the property, they are entitled to have rent paid. Okay.
thank you so much. I appreciate that knowledge.
All right. I try, because I know a lot of people are in the situation and they don't they're either they're coming from other jurisdictions or they're going by generally what is happening with them, but they don't have a sense of what the law requires.
Thank you
All
so
right.
much. I'm learning. I'm trying.
No problem. So the court will grant that on your counterclaim, and the management company failed to appear, so their claim is dismissed.
Thank you. You have a blessed day.
You too. All right. So next, we have next on the calendar is Opportunity Financial versus Coretta Rutledge.
Good morning, Judge.
Good morning.
Attorney Sandra Wolf on behalf of the plaintiffs. I'm not sure if the defendant or respondent is present. I do not believe so, but I'm not sure.
All right. So Ms. Wolf, let me call out one more time. All right. So Opportunity Financial versus Coretta Rutledge. Ladies and gentlemen, I know that sometimes you don't know the process for changing your name on the screen. If that's a problem, just unmute, let me know. I do see one person who's an iPad, but I don't know who that person might be. All right. So at this time, I'm going to allow you to present your case based on the defendant failure to appear. All right, so 1 second for all those of you who, hello, those of you who are not on this case of Opportunity Financial versus Coretta Rutledge, please mute your devices. All right. Milner Tribe are you on this case? Okay.
Certainly.
All right. Sir, please mute your device. All right. All right, Ms. Wolf, go ahead.
Judge, this is a motion for default judgment. There was a suit filed back in January of 2020. Service occurred in November of 2022. Service was obtained in November of 2022. There was an answer filed. However, it wasn't filed by the respondent. It was filed by the respondent's husband. There was already an order entered indicating that that did not count as a valid answer due to the husband not being the respondent or respondent's attorney.
Okay.
They were given 60 days to file any other motions relating to service, because I believe that they were indicating that service was improper. However, there was never any further motion served. So with that being said, and with them not being present, Judge, we would ask that the court find for plaintiffs and enter a default judgment. There should have already been an order presented to your office.
Yes. All right. So, did you present an affidavit of what was requested, or did you wish to present that today on the hearing?
Judge, there was an affidavit.
Has that changed in any way?
No, Judge.
Okay. All right. So the court is going to grant default judgment. It's going to strike the answer that was a nullity. It was not presented. It was not from an attorney or from the defendant. And the default judgment in this case will be granted in the amount pled for in the affidavit, based on the information presented to the court. We'll get an order out, and you presented an order. So we can go ahead and just sign that one and send it back. Okay.
Okay. Thank you, Judge. I have nothing further on the calendar. May I be excused?
Yes, ma'am. Thank you.
Thank you. Have a good day.
You too. All right. Alfonso Brinkley versus Omar Rashed.
Alfonso Brinkley.
All right, Mr. Brinkley. Omar Rashid or Rashed? Omar Rashed. All right, so this, is my understanding, is a review of a dispossessory from the magistrate court. Is that correct, Mr. Brinkley?
Yes.
So tell me what happened. Tell me about the lease, about the property, and why you're here.
I did the work to the property and he failed to pay. We made an agreement for him to pay. He had several projects going on and I completed about 4 projects. On the 5th
Okay.
project,
Let me understand, just for the record, let me make sure I'm clear on who you are. Are you a contractor that the landlord hired to repair property?
Yes.
Okay. And do you have a business or you work under your own name?
I have a business.
Okay. And but you're pretty much the sole person who does the work under the business, or you hire a few people to help?
Both.
Okay. All right. So who's the landlord and what did they hire you to do?
Omar is the landlord.
Mm-hmm.
I done something. I don't know. I hit something.
No, I can hear you. Can you hear me?
Yeah, but I put something in front of my screen. That's my first time doing this.
Okay.
I have an attorney. I have an attorney. He told me to tell you that he was in conflict.
Okay, he's in. Okay, so tell me who your attorney is.
Carlton. His name Carlton. Hold on. Okay. Anthony Carlton.
Okay, and did Mr. Carlton file a conflict letter with the court? Do you know?
I believe so.
Miss Powell, can you check that for me to see if Mr. Carlton filed a conflict? If so, we'll put this on another hearing date.
Judge, a conflict letter was filed on Monday.
Okay. All right. So, Mr. Brinkley, we're going to bring you back on another date when your attorney can be here to present the argument on your behalf.
Okay.
I don't have that you have I don't have the conflict on my calendar, but I'm ready to go forward when you all return. Okay.
Okay. So he'll get a notice of the new date.
Yes.
Okay. Thank you, Your Honor.
Thank you, sir. Take care.
Goodbye.
All right. In the next case, on the 10 a.m. calendar, Cindy Thevenin, Ketley Thevenin versus Finger and Sons Collision, Harley James versus State Farm Mutual. All right, so this is an auto accident and with a cross claim. Who's here on behalf of Cindy and Ketley Thevenin?
Good morning, Your Honor. My name is Brandon Smith on behalf of the plaintiffs.
Good morning. All right. Was there an answer filed? I see that the Finger and Sons and Harley James were pro se.
Yes, Judge. No answer filed. They're both in default. The court entered default as to James Harley. Finger and Sons is also in default, having failed to answer plaintiff's complaint. And I have submitted to the court the affidavit of service, both as to Harley and in his capacity for Finger and Sons.
Okay, and there was
no
no attorney on behalf of the company.
No, Judge.
Okay, and I see that the State Farm was dismissed from the case.
Yes, Your Honor.
All right, so so it seems like the cross claim goes away. Is that correct?
My understanding is that is correct, Judge.
All right, so the cross claim will be dismissed for warrant of prosecution, and we'll hear the claim in default.
Yes, Judge. And I brought Miss Cindy Thevenin and also her mother, Miss Ketley Thevenin. Both are wonderful people. To the extent Your Honor would have me present their damages in the form of their medical expenses and other losses.
I'm ready.
Outstanding. This arises out of a May 24, 2022 wreck when Cindy and Thevenin were in their vehicle, struck by Mr. Harley in the course and scope of his employment with Finger and Sons, resulting in their injuries, including disc herniations to both of them, also shoulder, head, neck, and back pain, thoracic pain, ultimately requiring multiple injections and treatment. Combined total medical specials are $35,238 and 40 cents. Judge, Miss Cindy is here and can testify as to her damages. I have her certified bills that I'd like to put in to the record, and I can be very quick.
That's fine. Go ahead.
Miss Cindy, can you hear me?
What is she listed as on the screen?
She is listed as iPad.
Okay. No problem.
Let me make sure she was texting me earlier, so let me make sure she's dialed in. If not, Judge, I can proceed to put in the bills and the bills. But I want to do that through her, and I want her to respond to that.
So let me send her a prompt that might help her unmute and also show her video. Okay. All right, for anyone here who's here on the 11 o'clock calendar, we're running a little bit behind, so please be patient. Go ahead and mute your device until we get to you. But you can go ahead and listen in, and this will help you maybe present your case once I get to you. All right, so Ms. Thevenin, I see you. Oh, now I don't see you. I saw you for a moment. Whatever you did, I was able to see you, but let me send you the prompt again. Okay, so it should be asking, okay, now. All right.
This is not her.
Okay, this is
no
your,
ma'am.
Okay, daughter, friend.
No, my name is Shonagay. I don't know who that is.
Okay, so you're not Cindy Thevenin.
No, ma'am.
Okay, what is your name?
Shonagay Riley.
Shonagay Riley. Spell it for me.
Okay.
Go ahead and spell it for me.
SHAWNAGAY. Last name is RILEY.
Okay. Ms. Riley, you're on the 11 o'clock calendar, is that correct?
No, they said it was 10 a.m.
Okay, you might be on the next, you're the next case. Okay.
Oh,
so just hold on, and I'm gonna mute you, but I'll get back to you in a moment, okay?
Okay.
All right. Mr. Brown, have you found your client? I mean, Mr. Smith, have you found your client?
She is there. She was trying to unmute herself and left the call. So she is logging back in right now, Judge. If it would help Your Honor to go to the next one until she logs back on. Okay. More than happy to do that. And I apologize for the inconvenience.
No problem. A lot of people are going through what I went through my first couple of months doing Zoom hearings. No problem. So 1803 Capital LLC and versus Shaw, Tomlinson Flowers, and Shauna Gay, Lanish Riley.
Yes, ma'am.
All right, so Ms. Riley is present.
John Swan for the plaintiff, Your Honor.
All right, so Mr. Swan is present for 1803 Capital. Have both Ms. Riley and Mr. or Ms. Tomlinson been served?
Yes, ma'am. They were served on the looks like December 8th, 2024. Miss Riley was served personally, and Miss Tomlinson was served by serving Miss Riley, a co-resident at 190 Morrison Trail, Hampton, Georgia.
All righty, so service has been perfected against the parties.
And in the answer that was filed in this case, Judge, I believe by Miss Riley, there was an admission that both of them were subject to the jurisdiction of this court. I'm not sure if the answer was just filed by Miss Riley or both of them signed the same answer. It's unclear.
I just see that it said defendant Riley answered. I don't know that she answered on behalf of both of them. I just have that she's not really able to do that. She can only answer on her own behalf. So that would mean that Tomlinson Flowers remains in default. All right, so if you so this Miss Riley, this is what's going to happen. So as the plaintiff, Mr. Swan is going to present the case for his client, 1803 Capital. Once he has presented that information, and if he presents it through any witnesses who are testifying as to what is owed, then you'll have the opportunity to ask any questions of those witnesses. Don't make any statements. Don't tell me what you think happened or know happened. Just ask questions of the person about things that they've testified to or about things that you want the court to understand. After that, if you wish to testify, then we'll talk about that, okay?
Oh, okay.
All right. So, Mr. Swan, did you have a witness did you wish to present in this case?
No, ma'am. This is a motion for summary judgment based on a failure to respond to requests for admissions.
Okay.
And as Your Honor noted, I guess Miss Tomlinson is in default. Tomlinson Flowers, I believe, is in default. No answer having been filed on her part. But we did serve both defendants with a copy of the request to admit.
Okay. So, Miss Riley?
Yes, ma'am.
The first thing that happens in a lawsuit is you get served with what's called a summons and complaint. The summons is supposed to tell you how much time you have to respond, and it's supposed to tell you what court the response needs to go to. So the summons is sort of like, hey, this is where the case is centered. This is how long you have to respond, and this is where you would go to file your response, clerk's office. The complaint tells you what they're suing you for. But after you've been served with a summons and complaint, then we have a process called discovery, which is where the person who's suing and the person who's answering, they can exchange information. In this case, Mr. Swan sent a request for you to give him information. That information has to be responded to within a certain amount of time, and it has to be responded to in a way where the court knows that your answers are true, so verified or under oath. So if you received that discovery and did not respond, Mr. Swan is asking that the case be decided in his client's favor because you did not respond to discovery.
Can I say something, ma'am?
Sure.
I received the serving paper, and when I went to the court, they told me that I was supposed to write my answers on a plain paper, which I did.
You did that.
And I asked the lady if my mom has to do the same. She said the paper could serve for both of us. So I filed it.
They're not supposed to tell you that because A, they're not supposed to give legal advice, and B, that's not true.
That's what she told me. So I asked her twice.
Okay. All right, was this for, this is for a debt owed, is that correct, Mr. Swan?
Yes, ma'am, on a promissory note, and an order was entered in the case, noting the fact that a military affidavit had not been filed.
Right.
We filed a military affidavit the date that order was issued on both of the defendants, indicating that neither of them was in military service at this time. Although our understanding is that since an appearance was made on behalf of Miss Riley, that a military affidavit did not need to be filed, but we did anyway for her and for the other defendant. And I'm assuming that the filing of those affidavits cures any problem that the court had with the motion for summary judgment.
Okay. All right. So, Ms. Riley, the summary judgment essentially means that they asked you to admit certain things. If those things aren't admitted by you or denied by you, then if you make no response at all, then the court can deem those as true. So whatever they asked you, if you didn't respond to it, then the process is now they're taken as true. And if they're taken as true, I'm sure the way they were structured, it means that you have admitted to owing the debt. You have admitted to owing the debt in the entirety of what Mr. Swan's client is claiming was the debt. So they would ask for summary judgment, meaning, Judge, there's no issue here because she failed to respond. All of the requests for admissions admit that there's a debt, admit the amount of the debt, admit that they failed to pay the debt. So at this point, we should receive a summary judgment, meaning we should win our case, and a judgment would issue against Ms. Riley. So that's where we are now.
But
Hold
on just a second, Ms. Riley, in case I misstated something. Mr. Swan?
You did not, Judge, although the order that we submitted provides for judgment against both defendants.
Okay. All right. Okay.
Judge, also just to add in, and I don't mean to misspeak here, but in the defendant's answer, she did deny some of the claims. So she didn't just file an answer that ignored what was being asked of her. She did specifically respond to the interrogatories.
Okay.
The responses were sufficient or not is a different thing, but just to be clear.
So she filed an answer that responded to the complaint, but did she file any response to the interrogatories or any other discovery?
We did not receive anything, Your Honor.
Do you find that in the record, Ms. Powell? Not
yes,
the answer, but anything after the answer?
Oh, I see. No, I don't. I'm sorry. Give me a second, please.
All right. Ms. Riley, did you have any questions about anything I said?
Yes, ma'am. I only received one paper, the paper that I was served, and I keep letting them know that I only received that one paper. I did not receive anything, and this is my first time doing someone suing me for something. So I just went ahead with what I was told to do. It wasn't yes, ma'am.
I'm sorry. Let me ask a couple of questions. Mr. Swan, where was the discovery sent?
Discovery was sent to the same address in which service had been perfected, 190 Morrison Trail, Hampton, Georgia, 30228.
Was it sent certified or regular mail?
Regular mail, Your Honor.
Do you know on or about the date that it was sent?
Yes, ma'am. It was sent on December 18th, 2024 to each defendant.
Okay. And was either of them returned?
No, ma'am.
All right. All right. So Ms. Riley, the court has asked Mr. Swan some questions about where the discovery was sent. You should have received 2 copies of it at that address, one for Ms. Tomlinson, one for yourself. But you're saying that neither of you received any of this information.
No, ma'am. If I did, I would have went to the courthouse because I don't really understand legal.
Okay, it would not have come from the courthouse. Have you moved?
No, ma'am.
Okay, so unless you can, because of the statements made by Mr. Shaw, unless you can provide me any reason to believe that you didn't receive the information, the court has to accept that they're deemed admitted. It would not have come from the courthouse, and you would not have been personally served. It would have just been a letter in the mail.
I know I checked my mailbox on a regular and I did not see it, ma'am. So I can't say I see something that I did not see.
Okay. All right, Mr. Swan.
Yes, ma'am.
All right. You said summary judgment, you wanted to move forward. Is there anything that you wanted to add to your summary judgment motion?
No, that would be it, Your Honor.
All right. So Ms. Riley, absent anything that says that you did not receive the discovery, the court finds that the requests for admissions were not responded to, so they're deemed admitted at this time. And the court is going to grant the motion, the summary judgment motion for Mr. Swan's client.
Can I say something, ma'am?
Yes, ma'am.
Why am I getting sued for something that I talked to the Mr. Swan clients about over and over, and they said I should not do such and such thing, and I didn't, and now I am at fault. I called them numerous times complaining about it, and they said I should not get a mechanic. I should bring it to them. Each time, even when I just got the vehicle, I called them and they said, do not call a mechanic, bring the vehicle back. And I called the number. I didn't know it was the loan office that I called. When I called, they called me.
All right, Ms. Riley, let me explain something to you. And this is the hard part for me, because a lot of people, because you don't understand how the law works, a lot of times you end up on the wrong end of it. So hopefully I'm explaining, I know this has not worked out well for you, but hopefully I'm explaining so someone else will get it. But what happens is you can call and negotiate things and talk to people, but that doesn't stop them from also filing a lawsuit. So sometimes you have to do both. If they file a lawsuit and you don't understand what's going on, you may need to seek legal counsel, because they can proceed with that even while they're talking to you about resolving it. And so even if they are speaking with you in the office about the finances or about the situation, that doesn't keep them from also filing a lawsuit. So, and if you get served with paperwork for a lawsuit and you don't understand what the next steps are, you can seek legal counsel. But when you proceed on your own and you don't understand what's going on, sometimes it will be a negative effect for you because you weren't aware of what the next requirements were. Okay. And unfortunately, I think that is what happened in this case. So,
I would urge Ms. Riley to get in touch with me to see if we can work out some kind of payment arrangement on this.
I do not have a job, and I've been out of a job since the last time I surrendered a vehicle. I only work one day, and that's it. I do not have a job.
okay.
So
I get it, Ms. Riley. The court is going to grant the summary judgment motion. But like I said, you can still talk to them after the summary judgment is granted about maybe how you pay or a payment plan, that kind of thing. But if you're ever served with paperwork and you don't understand what the process is for a lawsuit, you got to seek legal counsel. And there's some low cost or no cost options in Georgia Legal Services. There are indigent defense opportunities where people who either can be charged on a sliding scale or, you know, not charged because of pro bono volunteers. So at this time, ma'am, I'm going to get that information to you by mail, okay?
Okay.
All right.
Thank you, Judge. That's my only matter. May I be excused?
Yes, Mr. Swan.
Thank you. Have a good day.
You too. All right, are we ready on 2022 CV 02368 for Cindy Thevenin and Ketley Thevenin versus Finger and Sons Collision and Harley James?
We are, Judge. Thank you for your indulgence on that. Miss Cindy is here on another device, and I was mistaken. It wasn't iPad. It was the unlicensed room device that's on there, but that one's still active and still on, but she's on her personal device, I believe, right now under Cindy.
Okay.
Cindy,
Okay.
can you hear us?
All right. All right. So, Ms. Thevenin, I can't hear you, and it says you're not muted, which means that you need to choose computer audio. Okay, look at your screen. Do you see something that looks like an old-fashioned microphone? Okay. All right. It doesn't matter whether you mute or unmute, you're not connected to a microphone. So what you're going to do is, if you see the old-fashioned microphone, right next to it is a V. It's like an arrow pointing up. Click on that. And when you click on that, select a microphone. When you click same as system, that should help. You're gonna go to computer audio. Okay.
Judge, what if I called her on her cell, and would that work for you?
As long as we can hear it, that's fine.
Sure. Let me call her and
who's in the unlicensed room?
that was another device that she had that did not have access.
All right, Ms. Thevenin?
Yes, I'm here. I'm sorry. I'm using my laptop, but it's giving me issues. But I see you and I see everything you say, but it's
okay.
not
I hear you just fine now.
She hears you.
Let's go ahead and proceed. So the defendants in this case have not. Okay, so yeah, we're gonna have feedback, I think, if you use two devices, but the defendants in this case have not appeared. Finger and Sons Collision, James Harley, they're in default. So go ahead, Mr. Smith, and present your case.
Thank you, Judge. Ms. Thevenin, would you state your full name for the record, please?
Okay, you got to turn the other device on, I guess.
Say it again, please.
Thevenin?
Were you involved in a wreck on March 24, 2022?
Yes.
Did you suffer property damage to your vehicle?
Yes.
Were you injured in the wreck?
Yes.
Who is with you in the vehicle?
My mother, Ketley Thevenin.
Is your mother with you today?
Yes, she is.
Okay. Talk about where do you live?
I live at 356 Brennan's Court, McDonough, Georgia.
Okay. What do you do for work?
I'm a CNA, nursing assistant.
Nursing assistant. Great. Thank you so much. Tell us a little bit about what your life was like before the motor vehicle collision.
It was fun running. I did not have back problems or knee problems. I was completely fine.
Okay. And you recall suffering injury on March 24, 2022?
Yes.
Tell me what happened.
I was driving and the defendant came out of his business and without yelling or looking where he was going, and I ended up hitting him.
Were you struck on the driver's side or the passenger side?
Passenger side.
Was the vehicle totaled?
Yes.
Were the airbags deployed?
Yes.
Did Clayton County Fire respond to the scene?
Yes.
What did your body do inside the vehicle when you were struck?
It jumped against the wheel.
Okay. And a man named James Harley struck you. Is that your understanding?
Yes.
And at the scene, he was cited for no tag, no insurance, and failure to enter the roadway. Is that correct?
Yes.
All right. And you did not call 911, but a witness did call 911. Is that correct?
Yes.
How long did it take for the police to arrive?
10, 15 minutes.
Okay. Talk about all the injuries that you experienced in this wreck, please.
I did back, neck, knee.
Okay. And I have that you treated with Piedmont Henry Hospital on the day of the wreck. Is that correct?
Yes.
And then you were later recommended to attend physical therapy with Thrive Medical Partners.
Correct.
And then subsequently you went to Benchmark Rehabilitation, and then MRIs were ordered for you with American Health Imaging. Is that correct?
Yes.
Okay. I'm going to show you what I'll mark as your Plaintiff's Exhibit 1, which is a compendium of your medical records and bills. Judge, I'll share my screen with you just so you can see these.
Okay.
Miss Cindy, I'm sharing my screen. These are your medical bills with American Health, Benchmark, Piedmont, and Thrive. Is that a true and accurate breakdown of your medical bills in this case, totaling $22,327.40?
Yeah.
Okay, and I'm going to thumb through each one of them just to make sure that you see them and you can verify them as true and accurate. Have I done so?
Yes.
Okay, thank you. Did you receive any injections because of this incident?
Yes.
Talk to me about that. Where were your injections, and talk to me about your recovery?
I got injected to my back, my knee. The process was very painful. I still feel pain to this day from time to time. I've been struggling with my knee to walk. Yes.
Miss Cindy, are you still having issues to this day with your knee?
Yes.
What are some things that you're unable to do now that you were able to do before the wreck?
Stand a lot on my knee.
Okay, just standing hurts. Is that fair?
Yes.
Okay. Is Miss Kedley there? Your mother, is she there?
Yes, she is.
Okay. Can you put her on the phone, please?
Hello.
Hi, Miss Kedley. Nice to see you. Would you please state your full name?
My name is Kathleen Devenant.
Okay. And has your daughter accurately described what happened on March 24, 2022 when you were involved in a wreck?
Yeah, yes.
Okay. And I have that you also treated with Piedmont Henry on the day of the incident, as well as Thrive Medical Partners with your daughter, Benchmark, and also American Health Imaging. Is that correct?
Yes.
Okay. And I'm going to show you, and Judge, I'm going to share my screen, a summary of your medical bills as it relates to this case. Okay.
Okay.
Go ahead.
All right. Ms. Catley, you treated at American Health Imaging for and have $4,595 in bills. Benchmark Therapy for $1,008. Piedmont Henry Hospital for $3,272, and then Thrive Medical Partners for $4,336, totaling $12,911. Is that correct?
Yes.
Okay, thank you. And I'm going to thumb through just like I did before of the bills that you've seen. These are true and accurate representations of your medical bills that you've received in this case. Yes?
Yes.
All right. Thank you, ma'am. Talk about how you're doing now after the incident.
I don't do too well.
I understand. And I understand that you suffered disc herniations as well, just like your daughter did because of the wreck. Is that right?
Yes.
Okay. And talk about the pain that you experienced because of the wreck to your body.
I used to walk so well, but right now, oh, because I always have pain in my neck and my knees.
Okay, you used to walk very well, but you cannot anymore, and you have pain in your neck and your knees. Is that through the present day? Okay.
Yes.
And you also received injections as well, correct?
Yes.
Okay. Talk about the emotional distress and psychological impact, the emotional toll that this has had on you. Has this caused a disruption emotionally for you?
Yes.
All right. At the incident, were you in immediate shock and fear as to what happened?
Yes.
All right. And have you had any emotional difficulties, such as pain or anxiety or depression because of this?
Yes. I have anxiety and I have a lot of pain.
Okay. And Miss Cindy, I forgot to ask you in your examination, have you had emotional toll, distress, and psychological impact because of this?
Yes.
At the scene of the incident, were you in shock, fear, and mental distress? Okay.
Yes.
Okay. Is there anything that else that you all would like to add with respect to this case or what happened or your injuries?
No.
Okay. Judge, I'm going to hang up just so there's no feedback, just because I'm going to make a request for damages at your permission.
Yeah, that's fine.
Okay. Judge, with Cindy having $22,327.40 in medical bills, with Miss Kedley having $12,911 and no cents in medical bills, the combined specials are let's see, $35,238.40. Judge, in cases with ongoing limitations and permanent injuries, such as disc herniation, we usually ask for 10 times the medical specials, which in this case would be $352, $384. And I'll have, Your Honor, if you're willing to take judicial notice of the annuity mortality table, 1949. Ms. Kedley is currently 68. Cindy is currently 43. And under the under 1949 annuity mortality table, Ms. Kedley has 15.64 years left as a female. Cindy has 37.28 years left as a female. And humbly, Judge would ask just for $10,000 a year with their permanent limitations or permanent injuries and ongoing limitations, which for Kedley would be $156,400, and for Miss Cindy would be $372,800. Judge, I've also asserted attorney's fees under 1311-6. I was recently my billable hour was recently affirmed by Gwinnett County State Court at $750 an hour. Judge, I have just over $2,000 in expenses in this case. These defendant was initially very difficult to serve. We finally were thankfully able to serve them, and both Harley and Finger and Sons. Judge, a modest total and ask in this case for Miss Cindy would be, with her medical specials that I've described, with the 372,800 in mortality table, and half of what is about the 100 hours that I've expended on the case at $750 an hour. Her total would be $432,627.40. For Miss Kedley, who has less medical specials and less of an amount in mortality table, her medical specials are $12,911. Her mortality under the mortality table, it's $156,400. And I've effectively halved my attorney's fees for both of them under 1311-6. So her portion would be $37,500. And then Miss Cindy would be the same. That's how I got to the $432 for Miss Cindy. But for Kedley, her total would be $206,000, $811. Judge, I've also asserted reckless conduct and punitive damages in this case. There's no evidence that he was under the influence, although there was no tag, no license, and he was cited for failure to yield. Under the statutory cap, I would request humbly $250,000 in punitive damages against Mr. Hartley and Finger and Sons. I'm not gonna make that request combined. I'm just gonna ask for the cap of $250. Combined, Judge, today my ask is $889,438.40 for both Miss Cindy and Kedley for this wreck that they've had to live with for the last 3 years. Judge, I have a prepared order, have not filed it. I'm happy to do so at your Honor's discretion and at your convenience.
All right, so you've presented your case. There's no objection. The other party is in default and has not appeared. The ask total, including attorney's fees, is $889,438.40 for both parties. Is that correct?
Yes, Your Honor.
All right, and plus court cost.
Yes, Judge.
All right, go ahead and file your order. The court is going to grant that amount.
Thank you, Judge, so much.
All
Appreciate
right.
your time today.
All right, thank you, Miss Steven, and you're free to go at this time.
Thank you, Your Honor.
All right. For those of you who are on the 11 o'clock calendar, we've completed the 10 o'clock calendar. Thank you for your patience. I'm going to call the 11 o'clock calendar at this time. First case on the calendar is Swabu Olajuwon versus Atlanta Hospitality.
Your Honor, Keith Foster for Mr. Olajuwon. I'm sorry, Miss Olajuwon. I think we are here for a motion for default judgment.
Yes.
I did not bring Mr. Miss Olajuwon in because I was not sure how it worked. So I thought we'd do the default and then we prove our damages at the non-jury trial calendar. Or how does that work?
Don't try and chew my cabbage twice, so you can do the default and it just doesn't make sense to me to bring them back twice. Do you have an affidavit?
I don't have. I have an affidavit. I'm ready to prove the default. And if you will just allow me to go to at the end of the calendar, I can have Miss Olajuwon on and go ahead and be able to prove my damages today.
Okay. All right. So we'll go ahead and let's do it all at once. Go ahead and get Miss Olajuwon on, and we'll come back to you.
Okay. Thank you, ma'am.
You're welcome. Next case on the calendar is North American Wells Fargo Bank versus Ashley D. Rucker.
This case settled, Judge.
Okay, thank you. All right, next is Velocity Investments versus Anna Rodriguez.
Luke Stuckey here for the plaintiff, Your Honor.
All right. I saw Miss Rodriguez earlier. Anna Rodriguez.
I'm here, ma'am.
Okay, Miss Rodriguez. I'm going to ask you to start your video. You should get a prompt.
Yes, ma'am.
Go ahead, ma'am. All right.
Judge.
Yes, sir. Sir. Yes.
Ebony Miller, we were scheduled for 10 o'clock.
Okay, sir. I can't understand. I can't understand what you're saying. All right. So I heard 10 o'clock. Tell me what case you're here for.
Yes, ma'am. Ebony Milner Tribe, and I was scheduled for 10 a.m., but my name was never called.
And this is Charles.
I don't have a tribe on the 10 o'clock calendar.
This is Charles Brown for Fannie Federal National Mortgage Association. I have a NISI for 10 o'clock as well on that same case.
Okay, Ms. Powell.
Would you provide the case number, please?
Ready? 2024 CV 02221.
All right. So for Mr. Tribe, do you have a case number, or can you tell me who the other party is?
That was me, Your Honor. The case number I just gave.
So the Tribe family is on the other side of that?
Yes.
Okay. All right. Hold on. We'll get you in. Let me just go ahead and get this case done, and then Ms. Powell will bring me up to speed on that. Okay. Not sure why it was not on the calendar.
That was my error, Judge, but they did receive a Rule 9 SI, and I'll provide a brief shortly.
Okay, thank you. All right, so we'll thank you for your patience. Sorry about that, and we'll get right to you as soon as we finish this. All right, so Velocity Investments versus Anna Rodriguez. Ms. Rodriguez, you and Velocity Investments are before the court. They're asking, this is a suit on a contract, and Mr. Stuckey is going to present the case on behalf of his client. Mr. Stuckey, has there been an answer in this case, or are you asserting that there's a default?
No, Your Honor, there has been an answer filed in this case. The answer wasn't a denial, so I could ask for a motion for judgment on the pleadings based on that. However, we did file a motion for summary judgment based on discovery that was sent to Ms. Rodriguez and was never responded to.
Okay.
That was sent on January the 2nd of 2025 to 7036 River Hill Drive.
Okay. So Ms. Rodriguez, did you hear the case that I had with Ms. Riley?
No, ma'am.
Okay, you weren't listening to that?
I am so sorry, no.
No, that's okay. I was just hoping to that you had heard some of that information. No problem. So essentially, you were served with a summons and complaint. The summons tells you where the case is, like what county, what court, and it tells you, you have to respond within a certain amount of time. The complaint,
I did.
Okay, the complaint tells you what the case is about. When you answered, then the plaintiff then sends out information called discovery. So they're asking questions in discovery. If you fail to respond to that discovery, it's as if you're saying that you've admitted everything they said. Okay. So if you didn't answer those questions and send them back, then it's like you've admitted everything. And so they're asking at this point to have the case decided in their favor because you failed to answer those questions and respond to the court.
I got a letter from them telling me to pay $150 by, I believe it was the 2nd of August or something, but if I couldn't comply with that and I could pay less, or if I had any questions, go ahead and call them. Guess what I did?
Okay.
And I got cussed out. I was disrespected. This man just yelled at me over that phone like he knew me all his life. And I just did something like simple. And he just wouldn't let me speak. The moment I tried to tell him like why that wasn't a good time for me to do any of this. It just so happened that I am sick. I stay sick from COVID and I am on Social Security. I was living with $982 for the longest time, had to endure 2.5 months of no gas in my house. And right now I get $11.85 because they gave me back the money so I can actually, and they gave me Medicaid so I can actually take care of that. So
So Ms. Rodriguez, I'm sorry to interrupt you. And I understand that you're having a financial hardship, but that's not a legal answer or defense for what the plaintiff is asking. So the plaintiff is alleging, and please correct me if I'm not correct, Mr. Stuckey, that you engaged in a contract where money was borrowed and that money was not fully repaid. And so you owe, so that I guess initial contact was giving you the opportunity to start paying back the loan. But even if you're talking to them, they still have the right to file a lawsuit.
Yeah, I
You
understand.
still have to, okay, so you've responded to the lawsuit, but what you've responded to doesn't constitute an answer where you have a defense that the court could say you don't owe the money. You've essentially admitted, yeah, I owe the money.
Yeah, because I do owe the money. I'm not ever saying I didn't. I mean, I didn't owe no $15,000 because I made payments for 2 years or a year and a half, and they had sent me a letter that I got here saying that my debt was 7,000 and something, and with 1,000 and something for interest, it was 8,800 and whatever, and they've taken it back to 15,000. I
All
mean,
right, Mr.
I don't have one penny left out of my check, so I
Okay.
don't know what I can do.
Mr. Stuckey, can you explain to Ms. Rodriguez why the amount pled is 15,000 as opposed to the 8,000 that she believed she owed?
Look,
Yes, Your Honor. So we filed.
Hold on, Ms. Rodriguez. Hold on, just for a second. Just listen. Okay, go ahead, sir.
Yes, Your Honor. So we filed for $14,543.60 principal. And then there's additional interest and fees in the amount of $1,306.33. The entire amount financed on the loan was $14,250. That was the amount given to Ms. Rodriguez directly, and then there was a $750 prepaid finance charge. So it really comes out to $15,000. And there was an annual percentage rate on that loan for 22.73%. And so, yeah, I mean, given that, it's going to rack up interest and fees when there's no payments made on it.
Okay. So the amount that you're seeking on the summary judgment is, can you give me that total, please?
Yes, Your Honor. So it's $15,849.93, and then $266 in court cost.
Wow. Wow.
Yeah. So, Ms. Rodriguez, it appears that the difference that you are asserting is has to do largely with the annual percentage rate. So it's put you back essentially at what you borrowed. The amount that the court is going to grant judgment on is $15,849.93 plus court costs. Now, just because I've granted a judgment doesn't mean that you don't have any recourse. You can still talk to Mr. Stuckey and his client regarding a repayment. If you want to talk to them about a possible repayment plan, I understand that you're having a financial hardship at this time. Unfortunately, it's just not a defense to the lawsuit that would keep me from granting the judgment, but you may be able to speak with the client, Mr. Stuckey's client, or Mr. Stuckey regarding how you may begin to address that judgment, okay? If your hands are tied, your hands are tied, Ms. Rodriguez. I get that. Sometimes the situation just is what it is, okay?
Look, I just came from a hospital a whole week.
I got you.
What they told me, they have tried every medication there is for my situation, and none of it had worked. In other words, I was in that hospital, 207 blood pressure. They sent me on a 268. For what? Am I to die here? I just don't know how to tell the world this isn't my fault. This is a COVID thing.
Ms. Rodriguez, I got you. I understand. A lot of people fell into hardship during COVID, especially because they weren't able to work that way they wanted to. What I'm saying to you is, based on what the court has to do, I have to grant the judgment because legally that's what's required. But what I'm telling you is, I understand that you have a hardship. You still have the opportunity to speak with Mr. Stuckey and his client about how you might address this. But if you're unable to do so, there's really nothing that we can do at this point. So you understand the situation you're in. But if you're not able to address it at this time, it is understandable. Okay? All right. So I'm going to get this information out to you. And then if if you want to, I guess, reach out to Mr. Stuckey, that information will be in the order, okay? All right. And I hope things get better for you, Ms. Rodriguez, okay?
Thank you.
All right,
Thank you,
thank
Honor.
you.
May I be excused? That's my last matter.
You may.
Sir, did you hang up?
So look, no, I'm still here.
Yes. Okay.
Okay.
So do we talk now, or do I need to call you? What do we do?
Give me a call, Ms. Rodriguez.
Yes, sir.
All right, thank you.
Well,
Okay. And so, Ms. Powell, give me the case number and the parties for
can I go now, ma'am?
Yes, ma'am. You're free to go. I'm sorry.
Thank you.
Give me the case number and the name for the parties that we didn't have on the 10 o'clock.
Yes, ma'am. One moment, please. Okay, the case number is 2024 CV 02221. And the parties are Ebony Milner Tribe as petitioner and the Federal National Mortgage Association as the respondent. And I also sent you a chat with a little bit of additional information.
Okay. All right. So Miss Ebony Milner is present. Also the Mr. Brown, who's on here on behalf of Federal National Mortgage Association. Mr. Brown, Ms. Milner, is my understanding that this was heard in magistrate court and this is a request for appeal. Is that correct?
Yes, Your Honor. This is a petition for review from a dispossessory judgment. She was a tenant at sufferance post foreclosure.
Okay. All right. So Ms. Milner, tell me what's going on.
Judge, well, this is a case of land rights, tribal law, and treaties.
No, ma'am. No.
And I would just like to say that I'm a tribal member, part of the Cash Box Trust Tribe.
No, ma'am.
Governments.
No, ma'am. We're not doing that.
And American Indian landowner.
No, ma'am. So we're not doing all that. So this is a simple eviction. So you can tell me how much was owed, how much you paid, whether there's anything to that allowed you to stay in the property, or whether there's money owed to you. I don't do the whole trust, tribe, all of that, because that's not what we do.
Well, that's what this is in regards to.
Well, then, ma'am, that's not what we're doing here. I would either have to transfer you to a tribal court, which I don't know of one exists for you, or for superior court, because this involves a foreclosure. Essentially, he bought the house through a foreclosure. You were a tenant in the house at the time, or you owned the house and he bought it under the foreclosure. And then it was whether you get to stay in the house and pay rent or whether you're going to be evicted. Am I clear, Mr. Brown?
Yes, Your Honor. And
because I don't deal with I went to law school for 3 years, have practiced law for over 30 years, have been a judge for over 12 years. I don't do the trust stuff because that's some arcane, esoteric stuff that you all believe that we don't follow here in the judicial system.
I understand. Well, I would also like to say that I'm not here to handle any of my private affairs in the public.
Okay, so I'm not sure what that means. You asked for the appeal.
Yes, and as I was stating, I'm a tribal member, part of the Cash Box Trust Tribe, and also an Indian American landowner. So this case is in regards to trust and tribal land.
So the property, the foreclosure is on a house on tribal land?
Correct.
Which tribe?
I'm sorry?
Which tribe?
The Ebony Milner tribe.
No, sir. I don't know of that tribe, ma'am. So we
and all the documentation had been put on file as well.
Okay.
Post foreclosure.
I got all that, but here's the thing. So I'm gonna explain one more time. Whoever's in the background or their Miller tribe, not sure who that is. I'm gonna have to meet them. You're the one who's listed on You're the one who's listed on this case. So I can't hear from all of that. So here's the thing. Like I said, I've explained to you that if somebody purchases a home through foreclosure, then the people who were owners of the home or buying the home have two options. They can leave or they can be treated as tenants in the home. And in this case, it appears that Mr. Brown's client sought to evict you, and now you are asking for a review of that. So in my role in this court, I can go through the case as if it was never heard in magistrate court. But what I will tell you is I'm going to ask very specific questions. I'm going to follow the law under the state of Georgia with respect to landlord-tenant. And if you're not able to provide me that information, then I'm going to determine that you're not able to prosecute the case in the way that it needs to be, and I'll dismiss it for want of prosecution.
Well, again, American tribal landowner. So those laws that you may speak of don't apply to me.
No. Well then, okay, I'm going to dismiss your appeal for want of prosecution. The court does not have jurisdiction over American tribal land, nor is there a designation of this property being a tribal land. So at this point, the court is going to dismiss this for want of prosecution. Thank you. All right, next.
May I be excused, Your Honor? Thank you.
Okay, thank you.
Yep.
All right, so I'm gonna go back to the 11 o'clock calendar. That is Allstate Vehicle, and Property versus, UCL International.
Good morning or good afternoon now, Your Honor. Silas Harrington here on behalf of Allstate Vehicle and Property Insurance Company, ASO Janelle Booker.
All righty. Okay, and UCL International. Is there anyone here on behalf of UCL International? All right, Mr. Harrington, was the defendant served in this case?
Yes, Your Honor. And the court granted an order of default judgment as to liability on February 11th and set this hearing to determine damages.
All right, do you have damages in the form of an affidavit, or do you have someone who's going to be sworn and testify?
Your Honor, I have Miss Willis. I believe she just turned on her camera. This is unliquidated, so we do need a person to testify as to those damages. And
Okay,
she is
Ms.
here to do that.
Willis, you've been on for a while. Thank you for your patience. Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. Mr. Harrington, you're a witness.
Miss Willis, could you please state your full name for the court?
Ola Willis,
And Miss Willis, with whom are you employed?
Allstate Insurance.
In what capacity?
I'm a field adjuster.
Okay. How long have you been in that business?
9 years.
All right. By virtue of your training and experience, are you familiar with the fair market value of real estate and personal property?
Yes.
Are you also familiar with the reasonable cost of repair necessary to restore buildings to their original condition before casualty?
Yes.
And we're here today because the defendant's product caused a water loss incident at the insured's home, correct?
Correct.
And the home is located at 6733 Collar Way, Riverdale, Georgia, 30296, correct?
Correct.
And what was the fair market value of that home?
It was $218,100.
So was this property a total loss due to the water loss incident?
No.
The property was repaired, correct?
Correct, it was.
Okay, what was the reasonable value of labor and material used for the repairs to the home?
$4,377.54.
And what was the reasonable cost of the mitigation efforts to dry the home out?
It was $2,956.32.
So Allstate in this case has incurred a total of $7,333.86, correct?
Correct.
And Your Honor, we would ask for a judgment in that amount at this time. This was a refrigerator water valve. It catastrophically failed and flooded the home, basically. And I have a proposed order of judgment. I can e-file it if you want me to. I can send it to your office if you want me to, however you would like me to proceed.
You can send it to Ms. Powell, or you can e-file it and we'll sign it.
Okay, I will go ahead and e-file it today, and we'll look forward to seeing that whenever you get around to signing it.
All right, so the court is going to grant the amount in judgment pled for, and for which evidence was provided through your witness. Also will grant court cost in that case.
Thank you very much, Your Honor. May we be excused?
You may, Mr. Harrington. Ms. Willis, thank you.
You have a good day, Your Honor.
All righty. Noriko Roberts versus Louis Belgio, commercial roofing specialist, and Old Republic Insurance.
Your Honor, Brian Grantham on behalf of the defendants.
Okay.
Michael Warner on behalf of the plaintiff.
All right. All right. So this is an auto accident case. Is that correct?
Yes, Your Honor.
Okay. Plaintiffs, I'm ready to hear from you.
Your Honor, I think it's defendant's motion that we're here for.
I'm sorry. The motion isn't listed on the.
Oh.
Okay, go ahead. What's the motion?
There's two motions, Your Honor.
Yeah. Your Honor, we have two motions pending. We have a motion for summary judgment as well as a motion to strike part of Ms. Roberts' testimony as well as sanction her counsel for improper conduct during discovery. I'm
Okay.
gonna,
Is the motion for summary judgment depend upon the motion to strike, or can they independently be considered?
they can independently be considered, Your Honor, but they're somewhat related, and so I was going to argue them simultaneously, if that's okay with the court.
That works.
Okay, thank you. Your Honor, I'm sharing my screen. Is the court able to see that?
Yes.
Okay. So, Your Honor, this is a 3-car accident case, and this is generally the diagram of the accident. The large commercial truck you see was driven by my client, Mr. Belgio.
I see your heading. Your heading. So you got to go down to the next one. Next slide. I'll just see Roberts versus CRS et al.
I see. Do you see the diagram now?
No, I just see the list of slides, but it hasn't moved from the first slide.
I see. Let me
double click on it.
Let's try again.
Okay, that's Mr. Pitt's testimony.
Okay, there we go. All right. Now do you see the diagram of the accident?
I do not. I see where your cursor needs to go up to number 2, slide number 2, and then double click.
Mm-hmm. Okay. We'll try.
There you go. All right.
Okay, I was trying to play the slideshow. It wasn't working.
That's okay.
So it was a 3-car accident. This commercial truck is Mr. Belgio's truck. He was making a left-hand turn. Vehicle 2 here is driven by a gentleman named Mr. Pitts, who is not a party to this accident. Vehicle 3 here is Miss Roberts' vehicle.
Okay.
Mr. Pitts testified that the impact between his truck and my client's truck was at the very rear of my client's commercial vehicle where he had a forklift attached. There was no damage to Miss Roberts' vehicle whatsoever in the accident, and she testified as much. The photographs taken from the scene confirm that as well. Miss Roberts has repeatedly said that Mr. Pitts was speeding and that caused the accident. This is a renewal action. In the original action, she said that defendant Pitts was traveling at an excessive speed and failed to maintain his lane. She also said that he failed to properly maintain his lane and had improper regard for the speed of his vehicle. On the right side, there's a record where she lists the approximate speed of Mr. Pitts' vehicle at 60 miles per hour.
Making a left turn with a tractor trailer?
No, ma'am. I'll go back to the diagram. Mr. Pitts is right here at vehicle 2.
Okay.
My client is Mr. Belgio, who's making the left-hand turn.
Okay.
Mr. Pitts, you can see left about 160 feet of drag when he stopped.
Okay. All right.
So she wrote that Mr. Pitts was going about 60 miles per hour in the lane to her left. She testified under oath that he was speeding. I asked, do you remember if you alleged that Mr. Pitts was speeding excessively? She said, yeah. And I said, so in June of 2021, did you in fact think that Mr. Pitts was speeding excessively at the time of the accident? Ms. Roberts testified, yeah, I think he was.
So who's okay? If Mr. Pitts was deemed to have been or alleged to have been driving 60 miles per hour, and there doesn't appear to be contact between Mr. Pitts, am I missing something? Mr. Pitts' car seems to be headed to contact the tractor trailer from Belgio, and Miss Roberts' vehicle doesn't have any visible damage.
Correct.
I'm missing something. What's the proximate cause?
That is actually going to be part of the second motion that we filed, Your Honor.
Okay.
So Ms. Roberts admits that Mr. Pitts caused the accident. I asked her if Mr. Pitts hadn't been speeding, there wouldn't have been an accident, would there? She said there probably wouldn't. There probably wouldn't have. So that's her testimony. Now, in her complaint with respect to how the accident happened, what Ms. Roberts alleged in her complaint was that My client makes a left-hand turn. It caused Mr. Pitts to slam on brakes. She alleges that part of Mr. Pitts' vehicle struck her car in the accident, despite the fact that there was no damage to her car. So that gets into my second motion, which is our motion to strike testimony and to sanction her counsel. During, I put Miss Pitts, but Miss Roberts, excuse me. Miss Roberts repeatedly testified that her car was never struck by Mr. Pitts' truck or the trailer he was hauling. She repeatedly testified that only the tools from Mr. Pitts' trailer hit her car. She gave this testimony even while looking at documents which said Mr. Pitts' vehicle struck hers. We took a break during the deposition, and her attorney told her to change her testimony. So this is testimony that Miss Roberts gave. I asked.
Okay, so slow down.
Sure.
So my theory on attorneys and candor to the court is that we only need to be sworn in once, which is why when attorneys come before me and they say I stayed in my place, I'm relying on the oath they made when they were first sworn in as members of the bar. That carries them throughout their career. So you're stating that an attorney did something improper that would have violated the canons of practice by advising his client as to how to testify. Now, how do you know that that happened?
Because Miss Roberts testified that that happened.
Okay.
So during the first part of her deposition, I asked her, no part of Mr. Vitt's vehicle or trailer ever made contact with your car. Is that correct? She said, right. And I said, the only impact was some of the tools from Mr. Pitt's trailer hitting your car. Is that correct? She said, yes. As a matter of fact, she looked at this document where her own handwriting, she had written, an 18-wheeler pulled out in front of me, causing the car behind me to struck me. And I asked her about that. And I said, but the car behind you didn't hit you. It was just the tools, right? Yes. So she has said several times before we took a break, no part of Mr. Pitt's truck or trailer hit her car, only the tools. And she did that while even looking at a document that she herself wrote.
Okay, let me understand, because I don't know why I'm confused. I shouldn't be. So Mr. Belgio is driving the 18-wheeler with the tractor that and the trailer that is pulling around to the left.
That's correct. This is Mr. Belgio's vehicle one. Vehicle
Mr. Pitt is in a pickup truck with tools on the truck.
With the tools, he's hauling a trailer with tools on the back of it.
Okay, and it's an uncovered trailer. It's just like a flat trailer.
Like a landscaping trailer, you might say.
Okay, and what type of tools?
He runs a mobile car washing business.
Okay.
It's unclear to me what exact tools there were.
Okay.
But essentially what she has testified is that tools from vehicle 2 here and trailer 2 struck her car, and that's the only impact.
Okay, and then based on the visual appreciation of the vehicle driven by the by the plaintiff, there was no visual damage to the vehicle. Is that what your client is asserting?
Not only is my client asserting that, but Miss Roberts herself testified there was no damage to her vehicle. Okay. So that's the pictures show it, and Miss Roberts says it. Okay. So we took a break, and counsel coached Miss Roberts to change her testimony. I asked her, so your attorney said what to you during the break? Her attorney said, I need to clarify that not only the tools had hit my car, but that the trailer also had hit my car because it's in my paperwork. I said, before we took a break, you told me only the tools struck your car. Then we took a break. During that break, your attorney told you to clarify that the trailer struck your car as well, correct? Ms. Roberts said under oath, yes. Your Honor, under Georgia Rule of Professional Conduct 3.4, an attorney is prohibited from counseling or assisting a witness to testify falsely. The comment 1 to that rule states that you should not improperly influence witnesses, as was done here. Your Honor, counsel had other options if he believed that was the truth. He could have directed her after my examination. He could have shown her her complaint and said, well, is this true, or is what you testified true before true? He could have refreshed her recollection. Instead, what he chose to do was improperly coach her testimony. And Your Honor, I think this is important because at a deposition, a witness is to give testimony the way they would give it at trial. If we were in trial in your courtroom and Ms. Roberts had given the testimony she gave, and then we broke for lunch, and at lunch her attorney told her to change her testimony, that wouldn't be proper and you wouldn't allow that. It shouldn't be allowed in a deposition either. It's improper. It violates Rule 3.4 and it violates the spirit of the Georgia Discovery Statute. So the subsequent testimony should be stricken. Ms. Roberts wasn't confused. She didn't ask for me to clarify any questions. She testified, even when looking at her own handwriting, that that was wrong, and in fact, only tools from Mr. Pitt's trailer struck her vehicle. At a break, she was coached to change her testimony, and her explanation for the change was because it was, quote, in her paperwork. So the coached testimony shouldn't be allowed. Counsel's behavior was improper, and he should be sanctioned such that he's disinclined to engage in this behavior in the future. And I'd like to stop sharing my screen if I can.
Okay.
Am I no longer sharing my screen? Sorry.
Okay.
So, Your Honor, we should be entitled to summary judgment on the issue of Mr. Pitt's speeding being the sole proximate cause of the accident. This accident barely happened. Mr. Pitt struck the very rear of Mr. Belgio's trailer. The sole proximate cause here is the speeding that Ms. Roberts estimated at 60 miles per hour. Ms. Roberts said the accident would not have happened but for Mr. Pitt's speeding. And then the coach testimony should be stricken, and it should not be allowed at trial of this case if Your Honor doesn't grant summary judgment. Those are our motions and argument, Your Honor. Thank you.
All right. All right. So, Mr. Grantham.
That was me.
Oh, I'm sorry. Yeah, I'm sorry. Looking at the wrong, Mr. Horner.
Thank you, Your Honor. I'd like to address the motion for sanctions first. A little surprised, rare or maybe never being attacked personally, but I'm particularly surprised that in doing so, counsel for the defense would misstate and outright leave out important facts. The first thing I'd like to raise that was inexplicably left out is during the deposition of Miss Roberts, and granted she was all over the place, but in her deposition, the very first time she was asked about what happened that was on, anyway, I'm sorry, I lost my place. The very first time she's asked about what happened in the accident, she states that the trailer from his truck hit her car. This is on page 42 of her deposition. Did any part of Mr. Pitt's trailer itself hit your car? This is Mr. Grantham asking her these questions. I think it did. You think it did or it did? Yeah, it did. Okay, that's the first time this comes up in her deposition. Said the trailer hit the car. Now, granted, later on, then she says, no, it was only tools from the trailer that hit the car. And I submitted an affidavit in response, Your Honor. And in that affidavit, Mr. Grantham keeps talking about how I coached the witness, taking it as if it's a proven, established fact. First of all, I outlined pretty clearly the history of dealing with Ms. Roberts on this issue. Every time I met with, talked with, discussed this case with Ms. Roberts before her deposition, and indeed in the first part of her deposition, she always said that the trailer hit her car. And then all of a sudden, to my surprise, in her deposition, she says, no, it's only the tools that hit the car. We took a break. It wasn't initiated by me or Miss Roberts. And Your Honor, and this is what Miss Roberts said when she's asked about this extensively by Mr. Grantham. All I said to Miss Roberts was, I asked her first. I said, Miss Roberts, did the trailer hit your car, or did just tools from the trailer hit your car? She said, no, it was the trailer. I said, well, if that's the case, you need to clarify that, because you just testified that it was only the tools. I did not coach her what to say. I did not engage in any behavior that was contrary to any ethical rules, nor have I ever done so in my career, Your Honor. And so the only two people, and that's what Miss Roberts said when we come back for the break, and she said that. She said, I was told I need to clarify. And that's exactly what I told her, because she had said it 2 different ways in her deposition. Again, the first time she was asked this question, she said the trailer hit her car. So it is, that's a very important fact that was inexplicably left out.
Did you think about
I
addressing
get it
this
flies in
on
the face of the
Mr.
idea that
Horner?
this was invented whole cloth by me and Miss Roberts in a secret conspiracy at a deposition break.
Mr. Horner?
So anyway.
Mr. Horner?
Yes, ma'am.
You consider addressing this on direct after Mr. Grantham asked the question?
I'm sorry?
I said, did you consider clarifying this on direct after Mr. Grantham finished asking his questions?
Well, that's what I was going to do. But Miss Roberts, just in the middle of her deposition, said, I need to clarify something. When they went back on cross with Mr. Grantham asking her questions, she just out of the blue says that. So yeah, that was my plan to deal with it.
Okay.
But at any rate, the only 2 parties to the conversation. I'm sorry.
Can I ask just one question that doesn't seem relevant, but it is? What damages are being asserted?
Injuries.
To?
Miss Roberts. To spinal injuries.
Okay. Go ahead.
So at any rate, that's what I wanted to say about that. I think that's perhaps the most important thing in that exchange, is that this wasn't something new. This wasn't something surprising. This was what she had indeed said all along. And I just simply pointed out to her, I said, well, that's what you said. And she then took it upon herself to clarify. So that's the motion for sanctions. And Your Honor, I don't see anything improper about anything that I did. I did not coach Ms. Roberts to say anything. Regarding the motion for summary judgment, there's simply disputed issues of material fact. Ms. Roberts did say, well, this is that the statement that was put on the screen was a statement to her chiropractor that the other vehicle, the other passenger vehicle, not the commercial truck, was going 60 miles an hour. In the initial dismissed complaint that was filed by another lawyer, there were indeed unverified statements about the speed of the vehicle. But regardless of all that, the fact of the matter is Mr. Pitts himself, who is a witness, has testified that he was going the speed limit, that he was going 35. And as we point out in our response to the motion, some of the other facts seem to support that, namely that Ms. Roberts testified that that's about the speed that she was going, and that Mr. Pitts was behind her the entire way and never overtook her. So, not only does that sort of tend to corroborate what Mr. Pitts said, it also makes Miss Roberts, who Mr. Grantham is hanging his hat on her testimony, it makes her an unreliable judge of the speed of the Pitts vehicle, given that she testified it was behind her the entire way.
Okay, question. So, looking at the pictures that show the front and back, presumably, of the plaintiff's vehicle. So if Mr. Pitts' vehicle never overtook her, where's the damage alleged to have happened?
It's alleged that the trailer of his truck, when he hit the commercial truck, the trailer on the pickup truck jackknifed or did whatever it did and hit her car. That's what she said.
What part of her car?
I'm not exactly sure what part of her car.
So we just really gonna stand on notice pleading in this case?
I'm not sure what you mean.
I mean, has she stated anything more specifically? Because what Mr. Grantham is arguing is that your entire case rests on a person who's not even a party to the case being the sole proximate cause of the damages that cause spinal injuries in this case. The pictures that he's shown show no visible injuries that I can perceive.
No visible damage, you mean?
That damage that I can perceive, but you're alleging that the trailer of a vehicle moving anywhere between the speed limit, which 35 to 65 miles an hour, did not either made impact with her vehicle and caused her to suffer spinal injuries, or the tools from his vehicle that were in the trailer made impact with her vehicle that caused her to suffer spinal injuries, but he never overtook her, so all of this would have happened behind her.
Well, when the vehicles came to arrest initially after the accident, I mean, they were more or less side by side. I guess I'm not sure what your question is, Your Honor. I'm sorry. There is damage to her car. It's unclear whether there was any. It's unclear what damage, if any, was caused by the trailer in your car. That is true. I don't have pictures of her vehicle prior to the wreck. I mean, it's an older vehicle with other damage on it that is unrelated to this wreck.
Okay, go ahead.
So anyway, getting back to addressing the motion for summary judgment, that's a disputed issue of fact as to the speed of the Pitts vehicle. Mr. Pitts, who is now a witness, not a party, his deposition was taken, and his sworn testimony is that he was going 35. So right away, that's a disputed issue of material fact as to whether he was negligent or not. And even if Mr. Pitts was negligent, defendants have not established that he was an intervening, superseding cause. The officer in this case, the driver of the commercial truck, Bellagio, was questioned about this on page 15 of his deposition, but the investigating officer gave the commercial truck a contributing factor for failure to yield, which is exactly what we're alleging, that he blocked the entire road with his truck.
So he was cited for failure to yield?
Yes, ma'am. Or giving a contributing factor. I don't believe he got a ticket. I'm sorry, I misstated.
Okay, was anybody cited in this case?
I don't believe there were any citations, but the investigating officer did give him a contributing factor failure, but not a ticket, I don't believe. Sorry, I misstated that.
Okay, go ahead.
So to be a superseding intervening cause, it has to be an unforeseeable act of negligence that supersedes your own negligence. And again, first of all, there's a disputed fact as to whether Mr. Pitts was negligent at all. But even if he was, our allegation, this is exactly the kind of foreseeable risk that could have happened by blocking the road, that you would, by failing to yield, that you would block the road and thus cause an accident. And Your Honor, we cite numerous cases about the law on superseding intervening causes. So, you know, and the one statement by Ms. Roberts in her deposition, the one sworn statement, like Mr. Grantham said, she was asked, "Do you think this would have happened if he hadn't have been speeding?" She said, "Probably not." First of all, as I've established, she's not a reliable witness on that fact. Second of all, that's a but-for analysis, not a proximate cause analysis. And third of all, that doesn't preclude the initial negligence of the commercial truck as being the proximate cause of the wreck.
Okay, was there contact made between the commercial truck and Mr. Pitt's vehicle?
I'm sorry, Your Honor, I'm having trouble hearing.
Contact made between the commercial tractor trailer, Belgio's tractor trailer, and Mr. Pitt's vehicle?
Yes, Your Honor. Mr. Pitts hit the commercial truck, and then our allegation is that the trailer on the back of his truck jackknifed and hit Ms. Roberts' car.
Okay, and was there a traffic control device at this intersection?
No, there wasn't. It was a hill and a curve approaching the place where the commercial truck pulled out.
All right. Anything else?
Let me just check. Well, anyway, those are my main 2 points. That the issues are in dispute as to whether, to what extent Mr. Pitts was negligent, and even if he was, there's an issue of fact and law as to whether or not he was a superseding or intervening cause, which we think pretty clearly under the law.
Okay.
That's all I got.
All right. Anything else, Mr. Grantham?
Yes, Your Honor, if I may briefly respond.
Okay.
So with respect to the damage to Ms. Roberts' vehicle, I asked her on page 73 and 74 about the appearance of her vehicle. And she said that all the marks on the vehicle existed prior to the accident. I asked question on page 74, do you see any damage to the back of your car that was caused by this accident? She said, no, I don't see any damages. With respect to whether it was the tools or the trailer that struck her vehicle, she did initially say, I think the back of his trailer kind of hit her on the side. And then as I continued to ask her, I said, do you know that Mr. Pitt's trailer hit your car? And she said, I think it was the things that was on his trailer that flew. And so I asked her to clarify that. And she said, right, because he had some heavy tools. So then I asked her, so no part of Mr. Pitt's vehicle or trailer ever made contact with your car. Is that correct? She said, correct. And so then I said, so the only impact on your car was some of the tools from Mr. Pitt's trailer. She said, uh-huh. I said, is that a yes? She said, yes. And then later I showed her that exhibit that I showed the court. And again, she testified unequivocally that the only thing that struck was the tools and not the trailer. Now, with respect to the coaching issue, on page 74 of her deposition, she says she needed to clarify something. And then on page 75, she said she wanted to clarify and say it was a trailer. And she said it was brought to my attention. I said, question by your attorney. She said, yeah. I said, what did your attorney tell you? And Mr. Horner objected, and we went on. And I said, what did your attorney tell you on page 76? She said, but he just wanting me to like clarify up so he won't think like I'm just saying that the tools just hit my car.
Okay, Mr. Grantham. So let me ask, on page 42 of the deposition, had she said that the trailer from the vehicle hit her car?
She initially said, it looks like on page 46 of her deposition.
Okay.
So actually, okay, page 45, I asked her, was there any impact between Mr. Pitt's vehicle and your car? And she said, I don't remember seeing it, but I heard, hear like a bump or something hit my car. And then I said, what did you think it was? She said, I realized that was Mr. Pitt's trailer had swerved and all of his things and belongings and stuff was everywhere. And so I said, some of the things from Mr. Pitt's trailer hit your car. And she said, yes. So then on page 46, she says, I think the back of his trailer it's kind of indistinguishable what she says, but she says, I said, do you think Mr. Pitt's trailer hit your car? She said, I'm thinking that was the noise. I said, but you don't know. And she said, when I heard the bump, 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 yeah. And so on the next page, she clarifies and says, no, it was just the tools and not the trailer. So during her deposition, during my questioning, she changes her testimony and she consistently testifies that it was just the tools. She edits her testimony, which she's allowed to do. It's a discovery deposition. And even when I showed her a document that she had written that says that the trailer struck her, she says, no, that's not what happened. It was tools. And so, as I mentioned in my original argument, and as the court brought up, if opposing counsel thought that was incorrect testimony, the correct way to fix it is by refreshing her recollection on direct examination. Instead, what happened is counsel spoke with her in the hall and said, hey, you testified that it was only the tools. You should have said it was the trailer. We didn't come back from a break and Miss Roberts, of her own accord, without any conversation with her counsel, said, you know what? It was wrong what I said. I needed to say that the trailer hit my car, not the tools. She only made that clarification because her attorney coached her to do it. That's the only reason that happened. Now, again, he could have fixed it on direct examination, and then I could have recrossed and we could have gone through that. That's not what happened.
So let me ask one question. So, arguendo, the break happens. Mr. Horner has his client, I guess, away from wherever the deposition is taking place, and he says to her, you might need to clarify your testimony. Is that what you if he says nothing beyond that, is that what you would consider coaching?
Well, we don't have to guess, though, because we know what she said he said, and we know Mr. Horner submitted an affidavit. He says, paragraph 7 of his affidavit, during a break initiated by counsel for the defendants, I asked Miss Roberts whether the trailer from the Pitts truck hit her, as she stated to me several times before. She said yes. I then let her know that the testimony she had given made it sound like only tools from the trailer hit her vehicle, not the trailer herself. Okay. So we don't have to guess as to what the conversation was, because both counsel and Miss Roberts say that they had a conversation about the trailer striking the vehicle.
Okay. All right, go ahead. I'm sorry I interrupted you.
No, that's okay, Your Honor. That's the end of my argument, Your Honor. Plaintiff has made admissions that Mr. Pitts was speeding. If Mr. Pitts weren't speeding, this accident doesn't happen. Plaintiff herself admits that. But to the extent you don't grant summary judgment, I believe the testimony regarding the trailer striking Ms. Roberts' car must be stricken to comport with the Georgia Rules of Professional Conduct as well as the Georgia Civil Practice Act.
Your Honor, since it's very clear what I said and what I did not say, I would really appreciate if Mr. Grantham stopped inventing things that I said that, as we all know, I didn't.
Okay, so I
would appreciate that.
I don't want this to get contentious, because this is a a matter of utmost importance whenever we talk about an attorney's professionalism and whether they have in some way violated the canons or rules of practice. I take that very seriously. And so I will look at what the affidavits have stated. I will look at the deposition testimony was. I will look at the rule and any notes to the rule before I make a determination about that. Because the last thing one wants in the practice of law is to have your reputation tarnished by something of this nature. I was a civil attorney. I know how difficult it is when you have a person testifying, whether plaintiff or defense witness, and they are just all over the place. And so I understand how that happens. In fact, it is the norm. It is the norm as opposed to the exception. So let me look at the rules. Let me make sure that what is being presented, that I fully comprehend what is being presented and what is being argued on both cases, but particularly on the sanctions, because I take that very seriously. So I will make a determination on both of these issues with respect to the summary judgment, with respect to the motion to strike, and with respect to the motion for sanction. Okay.
Thank you.
All right, thank you. We'll get an order out to you as soon as I have done my due diligence and reviewed all of the information that you've all presented as well as the written information. Okay.
Thank you, Judge. That concludes my business. May I be excused?
You may both be excused. Thank you so much. You're free to go.
Thank you.
The next case I have is Jeff Lemon versus Aaron Norwood versus First Acceptance Insurance Company.
Good morning, Your Honor. Shannon Young, attorney for Davis Bozeman Law Firm, representing Jeff Lemon.
All right. Ms. Young, hold on just a second. So for Mr. Foster, were you able to get Swabu Olajuwon on?
Yes, Your Honor, he is on. Mr. Olajuwon.
All right. So as soon as I conclude the case with the Lemon versus Norwood, then we'll go ahead and take testimony in your case. Thank you for your patience. All
Thank you,
right.
Your Honor.
Ms. Young?
Yes, Your Honor. We're here today to determine the appropriate measure of damages for my client, Jeff Lemon, who suffered significant injuries due to an accident that he was involved in a 3-car accident, but the main culprit was the defendant, Aaron Norwood.
Is Mr. Norwood present? I'm sorry to interrupt, but I see a Samsung. I don't know who that is. And this is my last case on the 11 o'clock calendar. For the person who is listed as Samsung, can you show me your visual and unmute for me? All right.
I think that's Mr. Olajuwon. But
Okay.
I'm not sure though.
If you chat to Mr. Olajuwon, you can chat directly to him, and then we'll go ahead and figure that out. So, Ms.
It
Young,
is him, Your Honor. He just confirmed. I texted him and he just confirmed that was him.
okay, no problem. Ms. Young I see Mr. Hoyland is here on behalf of State Farm. Mr. Hoyland, do you have a dog in this fight? Or you?
Just here because I'm required to be here, Your Honor.
All right, so you can stay or go, which is at your pleasure. I'll go ahead and hear the presentation of evidence from Ms. Young. Let me just go ahead and change this so I know exactly who. Oh, yeah. All right. So, Ms. Young, my understanding is this was a car accident. Mr. Norwood was served and did not answer. Is that correct?
Yes, Your Honor. And we put in a motion for default judgment as of the 21st of February the order was granted. An order was sent granting us that motion. So the purpose of today is supposed to be focusing on the extent of his injuries and
Yeah, the unliquidated damages. All
Correct.
right. So are you presenting Mr. Lemon as your witness?
Yes, Mr. Lemon.
Yeah, he's on.
Yes.
Mr. Lemon, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, Ms. Young, your witness.
Thank you. Mr. Lemon, would you state your full name for the record?
Jeffrey Lemon.
And where do you currently live, Mr. Lemon?
I live in Atlanta, Georgia.
Okay. On January 2nd, 2023, were you involved in a motor vehicle accident?
Yes, I was.
Can you briefly describe what happened?
Well, I was traveling, I guess it was on 285 headed, it was headed east on 285. I was in the before left lane. There was a truck that was just to my right in my right lane. And then there was some merging traffic just right of the truck where Mr. Norwood was driving his that vehicle, his Charger. I saw him try to pass up a vehicle that was in front of him to squeeze between the truck that was just right of me and the car that was ahead of him. He was trying to squeeze in between the both of them. And when he wasn't successful at that maneuver, when he went over the truck hit him, the truck hit his vehicle spun and hit my vehicle, which forced me into the barricade on the left side of the highway. But that's what occurred.
Okay, thank you, Mr. Lemon. Now I'm going to show you a video real quick, and this is we'll mark it as Plaintiff's Exhibit 1. Can you see this video? Mr. Lemon, can you see the video?
Yes, yeah. Well, I see I see the video. It's not playing. Yes. Okay. Yeah, that was me videotaping the incident. That was after what occurred. That was from my phone video.
Okay, Mr. Lemon, how do you recognize that video?
Well, that was video that I shot. That was my vehicle that I turned to. That last vehicle that you saw, that was my vehicle. That was the car that I was driving.
Okay, so the vehicle that hit the side of the wall of the highway, that was your vehicle?
Yes.
And
Was that the light green vehicle, Mr. Lemon?
No, if she can play it back, it's the silver Camaro. It's a
Still,
Camaro.
I'm sorry. It looks like green based on I guess the time, but it was the lighter vehicle.
Right.
Would you
All
say would you say that the video fairly and accurately depicted the damage to your vehicle on that day, January 2nd, 2023?
Yes, it would. Yes, it did. There's other videos as well that I submitted because actually I had a video in the vehicle itself that captured the incident on camera.
Okay, so we're gonna we'll let that sit for now, and we'll go right into kind of how you were feeling right at the impact. Do you remember whether your head and neck snapped back and forward?
Yes, it was some. It jarred me from the right side, slamming me. When his car hit my car, it actually hit it twice because when the truck hit him, he spun and hit me. He spent again, and then the truck hit him again, and he once again hit and bounced off my car, and that's why he landed several feet up, and my car hit the embankment.
And Mr. Lemon, how soon after both of those impacts did you feel did you start experiencing pain or discomfort?
Yes, I was feeling discomfort in my right knee. It was it kind of shook me, and it kind of it shook me for a bit, but it was mainly what I was feeling from was from my right knee, injury from my right knee.
Okay. And did you seek any medical attention as a result of the accident?
Yes, I was taken to I was picked up by ambulance and taken to a regional hospital.
Southern Regional Medical Center?
Yes.
And prior to the accident, how would you describe your overall health?
It was I was pretty healthy. I mean, of course, just trying to work on changing my diet, but other than that, I didn't have no physical injuries. No.
Would you say that you were you experiencing any pain or physical limitations before the accident?
No, no, I wouldn't say that. No.
Were you able to perform your daily activities without any significant pain or difficulty?
Yes.
You still in there?
Yes.
Okay. After you arrived at the hospital, after Grady EMS took you to the hospital, you were seen at Southern Regional Medical Center, correct?
Yes.
And when you were there, do you remember what kind of treatment that you received?
They prescribed some pain medication because the pain that I was experiencing because of the accident.
Do you remember them taking any x-rays?
Yeah, they took x-rays.
Okay. And then before you got discharged from the hospital, did they recommend for you to do any additional testing or follow-up?
Yes, they did. It eventually they suggested that I go through therapy and things of that nature, and I did follow up through seeing a neurologist and also consulted with another neurologist, and they all suggested that I have surgery.
Okay.
I was later diagnosed with cervical stenosis.
So before that you saw before you were recommended for the surgery, did you go to Henry Family and Sport Chiropractic Center?
Yes.
Okay. And then while you were there, what kind of treatment did you receive there?
I was dealing with issues with pain in my neck, my back. Of course, it was just alignment, and that was just the treatment from the pain and the discomfort and stuff that I was feeling.
And when you left, while you were still being treated at Henry Family and Sport Chiropractic Clinic, did they also did they send you to get MRI done at Elite Radiology?
Yes, they did.
And then from there, did you start seeing Thrive Medical Partners as a result of what was on your MRI?
Well, they after the results of the MRI that exposes to what they had they saw me and they kind of said there was some irritation there. They then gave me a shot. They treated me, and then they recommended that I see other people, and that's when I was diagnosed with cervical stenosis.
Okay, with the shot that you're referencing, was that the epidural steroid shot?
Yes.
Okay. And Your Honor, at this time, I would like to just submit a brief copy of the medical bills.
You may. You want to share your screen? Go ahead.
Can you see my screen?
Yes,
Mr. Lemon, so you were seen by Grady EMS, Southern Region Medical Center, Small Hospital Innovations. That was the provider that saw you at Southern Regional Medical Center, Elite Radiology, Henry Family and Sports Chiropractic, Thrive Medical Partners. Does that sound about accurate in terms of all of the providers that you saw in relation to this accident?
yes,
And do you remember a total of about $26,299.60?
yes.
So, Your Honor, here in this exhibit that we're going to enter into evidence, it is a brief overview of all of the medical bills. Mr. Lemon, to your memory, does this look like a fair and accurate copy of the medical bills that you received?
Yes.
Okay, I'm just going to keep scrolling. Okay, so you said that this does look like a fair and accurate representation of the medical bills that were sent to you?
Yes, I have a copy of those records, yes.
Okay, perfect. Mr. Lemon, since the accident, have you had any difficulties performing your normal daily activities of life?
I have, yes, I'm actually going through physical therapy as we speak. I have therapy this afternoon,
And how often are you going to physical therapy every week?
twice a week.
Okay. Have you experienced any anxiety or trouble sleeping since the accident?
Well, yeah, I have issues with sleeping, yes.
Are you still experiencing those problems?
Yes.
Any fear while driving or riding in a vehicle since the accident?
I have some issues sometimes driving, yeah. But I just prefer not to.
Would you say your emotional well-being has worsened since the accident?
I'm finding some challenges. Yeah.
Mr. Lemon, in your own words, how has this accident changed your life?
I wish it would have never happened. If it was in a way that it would, if it didn't happen, that's what I would prefer. It has been some changes to my life, yes, since that accident.
Thank you for that, Mr. Lemon. And earlier you did mention that one of the providers did recommend that you have surgery. Have you since had that surgery?
I have, yes.
And is part of your physical therapy in response to the surgery or also for your knee?
Yeah, yes, that's it. I'm recovering from the cervical stenosis surgery that I had back in September.
Okay, well, no, I have no further questions, Your Honor. Thank you, Mr. Lemon.
All right, go ahead.
Your Honor, the evidence that we presented today has demonstrated that the full extent of the injuries suffered by my client, Mr. Jeff Lemon, as a direct result of the defense's negligence. The court has already determined liability, and the remaining issue is fair compensation for his injuries. As it stands today, the total cost of Mr. Lemon's medical expenses is $26,299.60. That does not include the surgery, so we are not asking to be compensated for that today. These numbers do reflect the extent of the medical expenses, but they do not capture the daily struggles that he faces, his injuries, cervical and lumbar disc herniation, strains, and persistent pain that have affected his mobility, his ability to work, and his overall well-being. He's also had to continue to get ongoing medical treatment. He still has physical discomfort and limitations that have disrupted his life in ways that no one should have to endure. So because of that, we are asking for $96,320 in past pain and suffering. The calculation, 602 days, is the amount of time that we calculated that Mr. Lemon has been experiencing this ongoing pain and suffering. We did it at a rate of $20 a day for 8 hours. So that's how we came to the total of $96,320. That, in addition to the $26,299.60, would be a total of $122,169.60 in total damages. An amount that we feel fairly compensates Mr. Lemon for both his medical expenses and significant pain and suffering he has endured. So we ask the court grant the full award requested. Thank you.
Okay. All right. So compensatory damages are $26,299.60. You're asking for past pain and suffering at $96,320. That's the total amount of damages for all categories of damages?
Yes, Your Honor.
All right. So the court will grant the amount of $122,169.60 plus court cost.
Thank you, Your Honor.
All right. If you'll go ahead and prepare the order, you can send it over directly to Ms. Kiera Powell, who's my staff attorney, or you can file it electronically and we'll sign it and send it back.
Sounds good. Thank you.
All right. Thank you so much.
Thank you.
That concludes my business today, Your Honor. Can I be excused?
Yes, ma'am. Thank you. All right. Thank you, Mr. Foster.
Thank you, Your Honor.
All right.
Mr. Elijah, go ahead and unmute yourself,
you.
sir.
All right. So sorry for the mix up. Thank you for your patience. And Mr. Olajuwon, you're represented by Mr. Foster on this case, 2022 CV 02700, Atlanta First Hospitality. I don't have anyone here from that company. And it is my understanding that they are in default. Is that the case, Mr. Foster?
That is, Your Honor. I checked this morning to the court docket as late as this morning, and there's not been an answer filed. And I think we're having some difficulty with Mr. Olajuwon unmuting himself. Mr. Olajuwon, if you look down at the bottom left.
Hold on just a second. Mr. Foster, you're free to go if you wish to, or you can continue to watch as long as you.
Yeah, I'll call him right now.
No, that's okay. Hold on. All right, I sent him a couple of prompts, which usually helps because all they have to do is click on them and it'll unmute.
Yeah, he just.
You know what? Okay,
Yeah,
there you
I
are.
think we got it.
All right.
Can you say something, Mr. Olajuwon?
Good afternoon, ma.
Good afternoon,
All right.
sir. All
Thank
right.
you, sir.
So it is my understanding, Mr. Foster, that you're presenting Mr. Olajuwon for the unliquidated damages in this case.
Yes, ma'am.
All right, Mr. Olajuwon, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma.
All right, you can put your hand down. You're a witness, Mr. Foster.
Your Honor, on December 8th of 2022, we filed suit against Atlanta One Hospitality LLC. On June 1st, 2023, we served with the registered agent. The answer was due on July 1st, 2023, with the grace period extending to July 16th, 2023. As of today, there's been no answer. Mr. Olajuwon, did you at some point you stayed at Atlanta First Hospitality, which was a Comfort Inn and Suites. Is that correct, sir?
Yes, sir.
All right. And while you were at the Comfort Inn and Suites, did you fall over an object that was protruding from the bed?
Yes, sir.
All right. Your Honor, if I may share my screen.
You may.
All right. Mr. Olajuwon, is this the object that was protruding from the bed in the hotel room at the Comfort Inn and Suites?
Yes.
Right. And when you struck that object, tell the judge what happened when you struck that object and what portion of your body struck that object.
My left leg, or like before my feet, I struck the object because the object was hidden under the bed browse or inside the hotel, which when I lifted up, I saw the sharp objects, like letting they use the cloth to cover it up.
Okay. So what you're saying is that there was like a bed sheet or bed drapery that covered up the object protruding from the bed?
Yeah, like to cover the sharp objects, like they hid it under the just cover because it was coming out from the part of the like below the bed, the lower part of the bed.
All right. And did you fall once you struck that object, sir?
Yes, sir.
All right. And did you at any point seek medical treatment for the object for the fall that you suffered on that day?
Yes, sir.
All right. And did you go to the Barber Clinic, Dr.
Yes.
Barber? All right. And hold on one second. If I'm going to share my screen again, Your Honor.
You may.
Mr. Olajuwon, is this a copy of the bill that you received from the Barber Clinic? $8,340.38.
Yes, sir.
And what, if anything, did they do there? Did they take an MRI of your left leg?
Yes.
And did you get electric stimulation to your left leg?
I can't remember. It's been a long time ago, like since 2022. Like it's been a long time. I can't remember, but when during the treatment, I have a lot of series of treatment, like my leg and my back, for them popping my back too.
And where were you injured as a result of hitting the that object protruding from the bed? Were you in where on your body were you
My
injured?
back, like my leg and my back, like my lower back.
All right. And on a scale of 1 to 10, with 1 being no pain and 10 being the worst possible pain, the pain at its highest, where was it when you first went to Dr. Barber?
Was like 9.
Okay. And did Dr. Barber ask you to go to, he asked you to go, and he also, I'm sorry, you also got another bill from Dr. Barber for $1,198.10. Is that correct?
Yes, sir.
Okay. And is this a fair and accurate copy of the bill that you received as a result?
Yes, sir.
All right. You also were sent to physical therapy, is that correct?
Yes, sir.
And you went to team rehabilitation, is that correct?
Yes, sir.
All right. And give me 1 second. And is this, and you had physical therapy at team rehabilitation, is that correct?
Yes, yes, sir.
All right. And your physical therapy started December 15, 2021, and all the way to February of 2022, is that correct?
Yes, sir.
All right. And when you finished your physical therapy at team rehabilitation in February of 22, I'm going to ask you the same question on a scale of 1 to 10, 1 being no pain, 10 being the worst possible pain. Where were you on the pain scale once you finished your treatment in February of 2022?
Was like 4.
Okay. And has your pain remained around a 4 in your lower back and your left leg since this happened?
Like since the incident, or it helped, like you go and come back, like when I stress myself, it's like a kickback.
Okay, so it'll go and it'll come back?
Yeah.
All right. And does that depend on the level of exertion you have done in the day?
Yes.
Okay. And does that, and did you have pain, recurrent pain that would come and go prior to the fall at the Comfort Inn?
Yes, sir.
All right, you did have that pain before?
No.
Okay. So before you fell, you did not have the pain in the left leg and in the low back?
Yes, sir.
Okay. All right. And how often would you say you have the pain in the leg, in the low back now? Would you say it's on a daily basis, once a week, 3 times a week? How often?
It's on daily basis. Like if I'm working, sitting down, the way I'm sitting down inside the car now, I'm going through pain.
All right, say that one more time. On 30-day
I said
basis?
on daily basis. Like when
On
I'm
a daily
working.
basis, you have it?
Yeah.
Okay, all right. All day, every day, or is it come and go during the day?
Like when I'm sleeping, like when I wake up, we kick back again.
I understand. In the mornings, typically.
Yeah.
And that was not present before you fell?
Yes, sir.
All right. All right, and you were working at the time this accident happened, were you not?
Working? No, like
doing Lyft, correct?
Yeah.
Okay. And I'm going to show you lost wages while you as a result of this. Is that correct?
Okay.
Yes.
Yes.
All right. And I am looking at it looks like you lost about $4,000 in wages. Is that correct?
Yes, sir.
All right. And since February of 2022, have you treated or have you lost any other wages since then?
No, sir.
All right. So your total amount of lost wages and your total medical specials would be $15,313.48, correct?
Yes, sir.
And the amount of lost wages would be $4,000 for a total of $19,313.48.
Yes, sir.
All right. And since December of 2021, you have been in daily pain as a result of the fall. Is that correct?
Yes, sir.
All right. Your Honor, we are requesting the $19,313.48. And then for pain and suffering, Your Honor, we're requesting $50,000 for the past pain and suffering and another $50,000 for the future pain and suffering. So a total of $100,000 in pain and suffering for a judgment of $119,313.48.
All right. All right, so present an order. The court is going to grant that plus court costs.
All right, Your Honor. Thank you so much.
Thank you.
Thank you, ma'am.
That concludes my business, Your Honor. May Mr. Olajuwon and I be excused.
Yes, you may.
Thank you.
All right,
All right,
thank
Mr. Olajuwon, I'll call you tomorrow.
Okay, thank you.
Uh-huh.